Hello, 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 check. Hello.
Good evening. Arey, I was having a class at GTB Nagar, so till 4:40. So it somehow managed. Okay, so we will try to wrap up. This looks voluminous, but this is not, because in the fag end of the material you will find statutory and constitutional bodies, which are predominantly static in nature, so that doesn't require much explanation. Okay, and there are few topics which are out of current affairs and few changes that have been brought in the law. Okay, okay, okay. This is the PDF. We have the. I thought synopsis. Have I entered some other batch? Okay. Now let's see if we can wrap up. I think we did fast track code. That was the last. Hmm? Personality rights are related to what you call these celebrities, their voice or their picture being misused. Okay. Alternative media. Contempt has been asked also. Contempt, how many times? There was a question. Contempt of Court Act has been amended. This thing has been doctrine of harmonious construction. We did. There was a question. Contempt of Court Act has been amended 5 times. This was a statement that was given in prelims 2 years back. But that statement was UPSC knew that you don't know, but there was a statement given that contempt of court has been defined in the constitution. Contempt of court has been defined in the constitution, which everyone knows that contempt of court is not defined in the constitution. So if you will eliminate that statement, you will get the right answer. So they sometimes, but you know, last 2 years, so from last 7 8 matlab 10 years they were asking question where you can answer by elimination, but now they are asking question one correct and two correct and three correct, which is actually tough. You will not be able to eliminate unless you know all the four options. There will be a confusion at the end, because you usually you will get answers where you are sure about one statement. Only one statement will provide the last year, the toughest question that was asked last year related to the election of president. In that, first two statements were very easy. The third statement, that the value of vote of one MLA of Puducherry, Kerala is less than that of Madhya Pradesh, and value of vote of one MLA of Puducherry is more than is Arunachal Pradesh is more than that of Puducherry. So these two statements, the first two were eliminated. There were four statements given. First two statements were eliminated, so two statements were left. So answer was either one correct or either two correct. So this was a tricky part, although answer either one correct was the correct statement, but two you eliminated, you were confused in two, that or both the two are correct or one is correct and one is not correct. So these kind of questions where larger information is required, information beyond the common what you call thing. Okay. See, it is like matlab diverse areas they are playing. They are having the liberty. UPSC is framing the question. Sometimes they will introduce like this: only one correct, only two correct, only three correct. Next year they will ask many schemes. Next year they will ask concept-based questions. Sometimes they will not ask a single question from history, a small, but some next year. So unpredictableness is there. So first thing that you should carry in the examination hall is next level patience and confidence, because 4 5 questions would be corrected just by absolute patience. Those tough questions which you will read, you will aram se understand that okay, the principal mandate behind asking this question is this. That is one thing. Second, which is very very important, that adequate sleep before the prelims. Okay, if you will sleep before the prelims for 8 10 hours, okay, ekdam aram se, okay, then that will be directly getting you 3 4 questions correct, which otherwise you will make mistake if you have not slept well. So many students who study at night, that's absolutely personal. I have seen people who study at night, they have also qualified. Those who study in the day, they also qualify. There is nothing like but before the exam, if you are not having in the habit of sleeping, then this is one of the most common complaint that you will find, that before prelims they were not able to sleep, On the day of prelims, नींद नहीं आई. This is one of the most common problem. So you get into the habit beforehand that on the day of prelims you should sleep adequate. If you will sleep, just sleep for a few hours and then attempt a. I say in the class also that if you are feeling tired, sleep for 2-3 days. Then you become relaxed and then your performance will go multifold. I teach the if I sleep well and if I am having a batch in the afternoon, that it will take next level. If I am having at 10 and I have not slept well, it will directly impact. So please understand this thing. Okay. Now this is Bharatiya Nyaya Sanhita. Now listen. There will be a question from BNSS. Okay. Bharatiya Nyaya Sanhita, and we know that they will be asking a question, and then if we make a mistake, then it is a bigger mistake. Bharatiya Nyaya Sanhita, it is common sense that they will not be asking sections. Okay. Section, if they ask, they may ask some section, जैसे section 124A in IPC. Now you have section 152 or 153 in the Bharatiya Nyaya Sanhita, but they have not used the term sedition. They have not used the term sedition. So, जैसे marital rape, section 375 of IPC, section 63 of Bharatiya Nyaya Sanhita. So, what UPSC expects the students to know? Undoubtedly, if UPSC cannot expect you to know all the sections, okay, it is possible, not possible, because there is a saying that lawyer only knows where the law is. No, lawyer doesn't know the law. So sections you don't need to remember. What are the mandates? One, what is the reason why we opted for Bharatiya Nagrik Suraksha Sanhita and Bharatiya Nyaya Sanhita? First important thing. Second thing, those sections which are related to UPSC, जैसे IPC 309, suicide, IPC 377, homosexuality, that was decriminalized, IPC 497, okay, that has been Joseph Shine case. Then what you call section 124A, these things you must know briefly. Regarding sections, I am not recommending you to go through the sections, but those sections which are frequently in news, which is expected from an average. Till now, you have not mentioned the sections of IPC in the exam. So you can download most of the police training academies in the state. They have developed PDF comparing IPC with that of Bharatiya Nyaya Sanhita or CRPC with that of Bharatiya Nagrik Suraksha Sanhita. Reason being simple, 1st July 2024 this comes into force. So now all the police stations will register FIR. A remote village in the state of Bihar will also register an FIR from 1st July 2024. So they must remember the sections which will be corresponding section of the erstwhile IPC. So India में कोई भी any offence is registered in a remote village of Karnataka or Kerala or Ahmedabad, ये Gujarat. So the point is, so they have developed, most of the police academies have developed comparative table of IPC with that of BNSS. If you will search on internet, you will get a PDF you can download, and you can just check few sections which were there in the Indian Penal Code, which are there in Bharatiya Nagrik Suraksha Sanhita. It will hardly take 5, although you don't need to go through sections, okay. For law exam and all India bar examination and all they ask, पर वहाँ तो open book exam होता है. You can carry the what you call ये law bare acts अपना carry कीजिए, okay. अब now जो कुछ चीज़ें news में है, first of all, what is the difference between Bharatiya Nagrik Suraksha Sanhita? I know many of you know this, but to take everyone along, Bharatiya Indian Penal Code, then you have the now is Bharatiya Nyaya Sanhita. Code of Criminal Procedure is now Bharatiya Nagrik Suraksha Sanhita. So Sanhita means code, okay. So Indian Penal Code, Bharatiya Nyaya Sanhita. Indian Code of Criminal Procedure, now Bharatiya Nagrik Suraksha Sanhita. And you have Indian Evidence Act 1872, which is Adhiniyam is law, Bharatiya Saksh Adhiniyam. First of all, you should, I know you know that what is the principal mandate of Bharatiya, बहुत easy है, सब कुछ दम नहीं है, गलत नहीं होना चाहिए, you should not make a mistake. So Bharatiya Nyaya Sanhita, 2 mandate is there, which I have said so 100 times, that the purpose of IPC is to define the offense and prescribe punishment. Define the offense and prescribe punishment. IPC, for example, 299 and 300 defines the homicide and 302 prescribes punishment. 499 defines defamation, 500 prescribe punishment. सो आईपीसी का काम है ऑफेंस को डिफाइन करना और उसके पनिशमेंट सजा को तय करना, प्रिस्क्राइब द पनिशमेंट. The job of CRPC is to prescribe the procedure to be followed in criminal laws. Now, what was the reason given by the government why CRPC was enacted? Multiple reasons. सबसे पहले let's take the name. Initially, it was called Indian Penal Code. So, Indian Penal Code reflects the thing that it is a sort of penalty. Okay. But now it is Bharatiya Nyaya Sanhita. Those who don't have Hindi as a vernacular language, Nyaya means justice. So, Bharatiya Nyaya Sanhita, Indian Justice Code. So from Indian Penal Code to Indian Justice Code, first there is a positive reflection. Okay. Code of Criminal Procedure. Yani there is a code for criminal laws procedure. Now it is called Bharatiya Nagrik Suraksha Sanhita. It is for the citizens' safety. The code that is for citizen Indian Citizens Safety Code. So now CRPC is having a positive mandate. Second is why only in Hindi. Okay. So I told on that day also. Article 351 of the Constitution, it shall be the duty of Union to promote the spread of Hindi language as an assimilating language that will develop Hindustani, matlab that a common expression for all the languages. So third important thing, what are the major changes? बहुत basic factual है कि what you call have bought all the laws, तो hard bare acts also. So इसमें क्या है भाई कि community service has been added as a punishment. Metropolitan Magistrate Court has been done away with. Okay. Always I said on that day, Section 6 of the Bharatiya Nagrik Suraksha Sanhita, Executive Magistrate Court is also a criminal court. Community service has been added as a punishment in minuscule minor, what you call, things. Some basic thing, judicial magistrate, first, second class can punish up to 1 year, first class can punish up to 3 years, chief judicial magistrate can punish up to 7 years, and there is no bar on the punishment by sessions court. Only thing that every death penalty that is given by the sessions court has to be confirmed by the high court. Next important thing, the constitutional provision. So all these matters fall within the domain of the concurrent list. Okay. So when you will buy erstwhile IPC, जब आप IPC खरीदेंगे, law के student होंगे, if you will buy IPC, so it will be written with amendments of Haryana, Rajasthan or any state. So in these laws, if they are enacted by the parliament and if the state wants to override the law, okay, a law on concurrent list which has been enacted, for example, there is a law related to offences against women. And one state wants that offences against women, we will prescribe more punishment than what is provided in IPC. एक स्टेट चाहता है कि हमारा पनिशमेंट ज़्यादा हो. Okay, फिर many laws are there. Okay, so that state will pass an amendment. So for that state, the bill will be approved by the president, not by the what you call governor. So if there is a law on concurrent list where the parliament has enacted a law, and if the state wants a stricter punishment for that particular state, then the law shall be approved by the president, not by the governor. Very simple, because if there is a law on concurrent list and the state wants to override the law on concurrent list by the parliament, then the permission will be given by the president. जैसे एक example, National Medical Commission Act 2019. National Medical Commission Act 2019 prescribe for UG undergraduate national eligibility cum entrance test, that is the NEET test, but the state of Tamil Nadu says कि ठीक है भाई, we will take admission on the basis of class 12th marks. So as per a law passed by the Parliament of India, because education including medical education including medical education falls within the concurrent list, while public health falls within the state list. Public health falls within the state list and medical education falls within the concurrent list. So Parliament passed a law कि नहीं, there used to be multiple exams, as you know, that All India Pre-Medical Test by CBSE, All India Institute of Medical Sciences, AIMS का test, JIPMER, PGI Chandigarh, Armed Forces Medical College, AFMC, Bihar Combined Medical College Association, Private Medical College Association test, then COMED-K, Consortium of Medical Engineering Dental, Karnataka, COMEDK. So different for admission into different medical colleges in the country, you have to appear for multiple interest tests few years back. So Parliament passed the law because medical education falls within the domain of the concurrent list. National Medical Commission Act 2019, which prescribes a uniform test for any medical college admission in the country on the basis of marks. Now, Tamil Nadu is of the opinion, which you must have heard, that admission should be on the basis of class 12th marks, not on the basis of NEET. Now, since Tamil Nadu wants to override, क्योंकि कोई भी मेडिकल कॉलेज रहे, चाहे वो श्री कृष्णा मेडिकल कॉलेज मुजफ्फरपुर हो बिहार गवर्नमेंट का, पटना मेडिकल कॉलेज, नालंदा मेडिकल कॉलेज हो, या ऑल इंडिया इंस्टीट्यूट ऑफ मेडिकल साइंसेज हो, उसका ग्रैंडफादर रेगुलेटरी बॉडी है मेडिकल काउंसिल ऑफ इंडिया, विच इज़ नाउ कॉल्ड एज नेशनल मेडिकल कमीशन. चाहे पटना लॉ कॉलेज अंडर पटना यूनिवर्सिटी हो, या जिंदल लॉ कॉलेज अंडर जिंदल यूनिवर्सिटी प्राइवेट, या नेशनल लॉ यूनिवर्सिटी बैंगलोर हो, या नालसार हैदराबाद हो, ऑल लॉ कॉलेजेस आर रेगुलेटेड बाय बार काउंसिल ऑफ India. So Dental Council of India, Bar Council of India, Central Council for Homeopathy, you have National Medical Commission, all these are regulatory bodies for education. Indian Council for Chartered Accountant Institute, ICAI, then you इसी तरह All India Council for Technical Education. For universities in general, you have University Grant Commission. So इस तरह regulatory mechanism है. So National Medical Commission, so medical education falls within the parliament concurrent list. So अब तमिलनाडु कह रहे हैं कि ठीक है भाई, we will take admission in our state run medical college on class 12th basis. So this law was passed by the state legislature. Now it is pending with the president. Reason being simple: if there is a law on concurrent list enacted by the parliament and the state wants to overcome that law, then that law needs to be assented by the प्रेसिडेंट. सो अगर भारतीय नागरिक सुरक्षा संहिता या भारतीय न्याय संहिता में वन सेक्शन अ स्टेट वांट्स टू अमेंड, इट हैज टू बी अप्रूव बाय द प्रेसिडेंट, नॉट बाय द गवर्नर. ये भी एक थंब पॉइंट है. नाउ विल सी हियर. अब कुछ भी नहीं है इसमें. फर्स्ट टाइम कम्युनिटी सर्विस एज वन ऑफ द पनिशमेंट. थ्रेशोल्ड फॉर गैंग रेप विक्टिम टू बी क्लासिफाइड एज मेजर इज फ्रॉम 16 to 18. Criminalizes sexual intercourse with a woman by deceitful means or false promises. So getting my point. So this is something which is there. Okay. It removes the offense of sedition. Technically speaking, it has not removed the offense of sedition. It has not used the term sedition, but I have discussed in the class also so many times, again repeating. Go and read section 152 and 153. They have not used the terms. Section 124A of the IPC said whoever by words either spoken or written or visible representation or any other form attempts to excite hatred towards the government established by law will be subjected to maximum punishment, that is imprisonment for life. अब उन्होंने क्या, whoever by words either written or spoken or by electronic communication or through financial support, getting my point, encourages secessionist subversive activities. So दो तीन चेंजेस किए हैं. पहला, दे हैव रिमूव्ड द यूज ऑफ टर्म सेडेशन. फर्स्ट. सेकेंड चेंज, दे हैव एडेड द टर्म इलेक्ट्रॉनिक कम्युनिकेशन, फाइनेंशियल मीन्स. दो. तीसरा, बहुत जेनरिक वर्ड था, एक्साइट्स डिसअफेक्शन अगेंस्ट द गवर्नमेंट स्टैब्लिश बाय लॉ. तो ये तो बहुत ही ज्यादा ओपन एंडेड है. इफ ही इज सिटिंग हियर एंड ही सेज टू हिम कि आई थिंक द गवर्नमेंट इज नॉट डूइंग वेल, so he is also exciting disaffection against the state government established by law. So that is why they have said encouraging subversive activities, secessionist tendencies, बहुत ज़्यादा उसको endangering the sovereignty, and you will read section 152 and 153, you will easily get. So उसको बहुत ज़्यादा open पुलिस के interpretation पे नहीं रखा, not an interpretation of the police, they have provided it more precise. और चूंकि sedition term राजद्रोह, you know the difference between nation and state. I hope you know that. So sedition was Rajdroh, not Deshdroh. There is a difference between Rajdroh and Deshdroh, anti-national and anti-state. So anyways, because nation is a very fluid concept. Okay. So ये एक changes आया है. ठीक है. Now excites secession अर्थात लिखा ही हुआ है यहाँ पे. Armed rebellion, subversive. हाँ थोड़ा सा they have doctrine of strict liability also. They have see the point is with ये सब UPSC will not ask कोई contract का. Now you have separatist activities endangering the sovereignty or unity integrity of India, organized crime, continuing unlawful activity including murder or grievous hurt by a group of person. ये इन्होंने add किया है because of mob lynching. Okay, because of mob lynching, murder or grievous hurt by a group on grounds of race, caste, community. Okay. Okay. Race, caste, community, sex, okay, place of birth, language, personal belief, okay, death. So, ek, they have added related to mob लिंचिंग, दूसरा व्हाट यू कॉल सेडिशन, कम्युनिटी सर्विस, कुछ सेक्शंस मैं बता, टाइप्स ऑफ कोड सेक्शन 6, ओके, सो दिस यू कैन सी, आई थिंक उससे ज़्यादा बीएनएसएस में नॉट. सो prior to 1860 parliamentary charters and all were made, that is these things the UPSC can ask, okay. Several law commission recommended amendments, many law, you know, law commission of India is a extra constitutional non statute body established for 3 years, that is to make recommendations with respect to changes in the laws and all those things, okay. Now we have भारतीय नागरिक सुरक्षा संहिता. अच्छा, इसमें एक सेक्शन ऑफ रिपील भी होता है लास्ट में, ओके. इट इज ऑल्सो हैविंग अ सेक्शन ऑफ रिपील, कि भाई पुराने लॉ को हम रिपील करेंगे एंड दिस लॉ विल कम इनटू फोर्स. लेकिन ऑलरेडी जो केसेस रजिस्टर्ड हैं आईपीसी में, दे विल गो ऑन एज पर आईपीसी. ओके, नाउ वी हैव कोड ऑफ क्रिमिनल प्रोसीजर, नाउ वी हैव भारतीय नागरिक सुरक्षा संहिता. सो ये इसमें क्या है, नाउ इसमें दो तीन चीजें हैं. पहला, दिस वी डिस्कस यस्टरडे, नो, कि वी नो दैट अंडर ट्रायल्स को लेकर देर, यू नो, एज मेनी ऑफ यू नो दैट अंडर ट्रायल्स एंड द कन्विक्टेड पीपल, अंडर ट्रायल्स एक कॉमन सेंस है कि अंडर सी दे विल नॉट बी आस्किंग यू, दे कैनॉट एक्सपेक्ट यू टू first of all, if you what you call deeper aspects of law, it is not that you cannot answer. If they ask about deeper aspects of law, ऐसा नहीं है कि आप जवाब नहीं दे सकते, because it is not there in the syllabus, so you have not studied, you have not studied, so there is no need to study because it is not prescribed in the syllabus. Otherwise most of the students I teach are academically competent, that if you will go through the what you call very easily you will have a basic understanding of the law. कुछ ऐसा कोई बहुत rocket science नहीं है, okay. So the even law college में, if you will see, many law college are facing this problem, majority of them are preparing for civil services. So actually एक बार law का entrance भी prelims के दिन रख दिया था 15 years back, so that students who are actually interested in law, so otherwise they don't expect you to know these things, okay. अब ये है कि भाई those first time offenders who have completed 1/3, so इसमें 3 पॉइंट है. पहला, फर्स्ट टाइम ऑफेंडर्स जो है, अगर 1/3 वट एवर इज द मैक्सिमम पनिशमेंट, if they have spent 1/3 as the under trial, then they will be released. For others, if they have spent half of the maximum period, they will be released. I am again saying, those people who have not been convicted, they are an under trial. If they have spent 1/3, if they are first time offenders, if they have spent whatever is the maximum period of punishment, if they have spent 1/3 of that in jail as an under trial, then they will be released on bail. Second, those people other than first time offenders, if the maximum punishment is 3 years or maximum punishment is 7 years, and if they have spent up to 3.5 years, that is half of it, then they will be released, okay. All such, ye basically Supreme Court mein you have Jalaluddin Khan case, yesterday we were seeing that is what you call bail is the norm, jail is an exception. वही basic है, कुछ भी नहीं है. मेडिकल एग्जामिनेशन, इस पे एक लॉ है जो क्लास में इट इज कवर्ड बट नॉट. इंडियन प्रिजन्स एक्ट 1920 रिप्लेस्ड बाय criminal procedure identification act, criminal, this they can ask after few years, okay, they can ask. I'm just saying you the month, you just go through. I think March 2022 था, फिर भी मैं एक बार देख लूँ, okay. So Indian Prisons Act, what you call Criminal Procedure Identification Act. Today only I'll share with that, okay. So just see, I think 2022 March के around होगा, okay, March 2022, okay. So Indian Prisons Act 1920 has been replaced by Criminal Procedure Identification Act 2022. What is the difference? This can be a prelims statement. इस बार उन्होंने प्रिवेंशन ऑफ टेररिज्म एक्ट जो कि 2002 का लॉ था, वो दे हैव आस्क्ड इन 2023 प्रीलिम्स. सो इंडियन प्रिजन्स एक्ट 1920 में लिस्ट ऑफ थिंग्स वर गिवन कि व्हेन अ पर्सन हु इज अरेस्टेड, these all details can be collected, as very commonly in Hindi cinema or Hollywood cinema you must have seen a person carrying a small board like this, his name and his date of birth and all. So these details were collected, some thumb impression, handwriting specimen, signature. So now the or some what you call some his physical attributes, his height. Now they have increased the ambit. Criminal Procedure Identification Act 2022 में, which I usually do in the class also, and I'm asking you to visit also. You will find this in the March 2022 Current Affairs of Vision IAS, as far as I remember, 99%. Maybe it can be, I'm not sure. It can be April also, but just go and check. I'll let you know today only. So उसमें क्या है? What are the changes in the act? उसमें they have increased the ambit that not only they can collect the physiological features, बहुत सारी चीजें और they can collect, first thing. Second, who can collect? Even the head constable can collect. What are the concerns with the act? That is not required from prelims perspective, that you will cover from mains perspective. Otherwise, prelims में what are the changes? Indian Prisons Act 1922 1920 replaced by Criminal Procedure Identification Act. एक बार जरूर देख लीजिएगा. Okay. Now this is the key provision. Medical examination से ही याद आया मुझे. So any police officer can make a request from a forensic investigation specimen. हाँ. May 2023 current affairs में you will find what you call the difference between narco analysis test, polygraph test and brain mapping test. Brain mapping test. Okay. Just a second. I'll just share that with you. So just 1 second. I'll just share. So with so you will see this what you call brain mapping test and polygraph test and what you call narco analysis test. Okay. I'll share, don't worry. So this is so that also you see what is the difference between brain mapping test, narco analysis test and polygraph test. In narco analysis test, sodium pentothal is injected. So it is an invasive test. It is an invasive test where sodium pentothal is injected and the person goes into semi-conscious state. So if you are in semi-conscious state, you speak without any inhibition. You speak. अब ये सब UPSC बहुत क्वेश्चन पूछने लगा. Basic. Every day you hear narco analysis test, brain mapping test, and polygraph test. So in narco analysis test, a injection is given, that is sodium pentothal, that will lower the consciousness of the person and will allow you to speak without any inhibition. For example, a person who is in drunken state. So although I don't drink, I don't know, but I hear that people go and speak anything. So why they speak? Because they take the route of, because they are in a semi medulla oblongata is affected. So इसमें भी उसको सुई दी जाती है. He goes into semi-conscious state and then he will be speaking without any inhibition. First important thing. Second important thing, in brain mapping test, a machine device is attached. When you speak, they will record the physiological movement of the brain and all those things. That if you speak falsehood, it is more of a physiological test. ऊपर से. Then you have what you call brain mapping polygraph test. Polygraph test में सब कुछ आएगा. From blood pressure, from heartbeat, everything. They will sweat glands, from movement of legs, सब evaluate करेंगे. That if you speak false, these are the changes. So invasive test जो है वो narco analysis test है, and there are number of judgments, Selvi and others versus State of Karnataka, Supreme Court ने कहा था कि no person can be forced to go through narco analysis, brain mapping and polygraph test, and even if they themselves take these tests or in extraordinary circumstances, that cannot be used as a primary evidence, it will be used as a secondary evidence. There are many other evidence, this can be an adducing evidence. Okay, so this is there, so all these things are there. अब this important, usually it was first enacted in 1861. Of late UPSC has started asking these things. Basic point, CRPC 9, Law Commission of India 41st report. CRPC, you know, there was CPC is of 1908, but CRPC was comprehensively amended in 1973. Reason being simple, Article 50 of the Constitution, the state shall take steps to separate judiciary from executive in the public services of the state. I have repeated this many times. उस दिन भी मैंने पहले दिन भी कहा था. 3 examples I always give. Article 50 says the state shall take steps to separate judiciary from executive. This UPSC will not ask. But second part, that is in the public services of the state. That is what UPSC expects you to know. Article 21, the state shall provide free and compulsory education to all children in the age group 6 to 14 years in the manner state may determine by law. सेकेंड पार्ट जो है दैट यूपीएससी विल आस्क, दैट राइट टू फ्री एंड कंपलसरी एजुकेशन एक्ट. सो फर्स्ट पार्ट इवन एवरेज कॉमनर नोज दैट. उसी तरह जैसे आर्टिकल 40, द स्टेट शैल टेक स्टेप्स टू एस्टैब्लिश विलेज पंचायत एंड इंडो देम विद सच पावर्स सो एज टू इनेबल देम टू फंक्शन एज यूनिट्स ऑफ सेल्फ गवर्नमेंट. ओनली इंपॉर्टेंट थिंग इन आर्टिकल 40 विच यूपीएससी विल आस्क इज सेल्फ गवर्नमेंट. एवरीवन नोज दैट आर्टिकल 40 इज विलेज पंचायत. सो ये सारी चीजें. नाउ वी हैव भारतीय साक्ष्य अधिनियम. दिस इज अ वेरी ब्रीफ लॉ. So Indian Evidence Act 1872 which governed by admissibility of evidence. इसमें कुछ what you call electronic or ये मैंने देखा अभी हाल मतलब I was going through all the laws. I bought the hard copy books also. So the point is कि Indian Evidence Act में कुछ major changes किए हैं, जैसे what you call electronic records are admissible as an evidence. Then there are primary evidence and there are secondary evidence. Primary evidence जो सीधा you are producing the document. Secondary evidence हाँ, always remember digital evidences are also primary evidences. Digital evidences are also primary evidences. Secondary evidences ki you are producing a photocopy or I saw the document and I'm saying that I saw the document and this is that. Getting my? Otherwise the primary evidences are best. I don't want to go into Evidence Act. It's an interesting law. Okay. Oral evidence has to be given electronically, include statement and joint trial of multiple persons. Admissibility of electronic evidence or digital records as evidence. Okay. Now this is very important. डिजिटल पर्सनल डेटा प्रोटेक्शन एक्ट. ओके, अब इसमें बहुत साल लग गए. इट टुक 5 years फ्रॉम केएस पुट्टा स्वामी जजमेंट. इन इंडिया दिस इज अ लाइकलीहुड क्वेश्चन फॉर. अभी तक जितना मैंने किया है उसमें भारतीय नागरिक सुरक्षा संहिता, भारतीय न्याय संहिता एंड डिजिटल पर्सनल डेटा प्रोटेक्शन एक्ट कैन बी अ क्वेश्चन. ओके, सो अंडर डिजिटल पर्सनल ऑल्दो और भी चीजें चेंज हुई हैं. द रिप्लेसमेंट ऑफ इंडियन टेलीग्राफ एक्ट 1885, the cinematograph rules 2024. Okay, last year cinematograph rules, the cinematograph amendment act 2023. ये सारे changes जो I'm reading for past 2-3 years they can ask. Now coming here, अब this is a very important law. After right to privacy being declared as a part of right to life under article 21 of the constitution, इंडिया में जैसे जनरल डेटा प्रोटेक्शन रूल्स है यूरोपियन यूनियन का, वी वांटेड अ लीगल फ्रेमवर्क. क्यों लीगल फ्रेमवर्क? वॉज फर्स्ट ऑफ ऑल डेटा प्रिंसिपल, डेटा फिड्यूशरी. ओके, डेटा प्रिंसिपल एंड डेटा फिड्यूशरी. व्हाट डू यू मीन बाय फिड्यूशरी? फिड्यूशरी लॉ में एक बहुत बड़ा टर्म है. मेनी ईयर्स बैक आई फाइल्ड एन आरटीआई फॉर माई आंसर स्क्रिप्ट. So the RTI reply was given that this is your marks. Related to answer script, there is a fiduciary relationship between the examinee and the examiner. So if there is a fiduciary relationship, it is exempted from disclosure under RTI. जैसे husband wife have a fiduciary relationship. In many cases, any statement that is given by husband to wife, wife to husband is also a confidential information. So many information which is based on fiduciary cannot be revealed. So what is fiduciary? When you are creating an account for a social media, so that social media entity is a you are giving that information on the basis of ट्रस्ट. सो इसमें कौन कौन सा टर्म है? डेटा प्रिंसिपल, हमारा जिसका डेटा है, आई एम द पर्सन हुज डेटा इट इज देयर, तो आई एम द डेटा प्रिंसिपल. फेसबुक और इंस्टाग्राम इज टेकिंग माई डेटा, इट इज अ डेटा फिड्यूशरी. उसमें भी है बिग डेटा फिड्यूशरीज. कुछ है स्मॉल साइट्स आर दे आर कलेक्टिंग स्मॉल डेटा, बट सम दे हैव सिग्निफिकेंट साइज, दे आर बिग डेटा fiduciaries and data intermediaries also sometime there. Digital Personal Data Protection Board is there. Okay, so in India we were not having a law that will provide framework to safeguard the information of data principal and data fiduciary. So what are the, so इसमें इस law में क्या क्या चीजें हैं? What are the rights of data principal? What is your right? Right, you will give only that information which is required. What is the responsibility of data fiduciary? After using your information, they will delete. They will ensure that there is no leak of data given. You have a right to any data that is about you. After the use, you have the right to get it what you call removed, all such things. So इसके लिए जो law pass हुआ, that is Digital Personal Data Protection Act. Regulate the process. You know, data is the new oil. Regulate the processing of digital personal data. Data fiduciaries, persons, companies and entities who process data for data processing. Rights and duties of data principal, that is person to whom data रिलेट्स एंड अब इसमें क्या क्या है भाई, डिजिटल पर्सनल डेटा विद इन इंडिया, processing of data outside India, okay, does not apply to all these exemptions. Consent only for a lawful purpose, okay. Consent will not be required for legitimate uses. Data Protection Board of India bana hai. It will ensure the compliance to the law. The law is being implemented. Monitor the compliance, directing data fiduciaries to take necessary measures in event of a data breach. You have hearing grievances affected by persons. Board members will be appointed. Yani, in order to safeguard the interest of the data principles and regulate the proper implementation of the law, you have Data Protection बोर्ड ऑफ इंडिया. अब ये क्वेश्चन पूछ सकते हैं कितने मेंबर्स, ऑल दोज थिंग्स. अपील इनके खिलाफ आप जा सकते हैं. लाइव विद टेलकम डिस्प्यूट सेटलमेंट एंड एपलेट ट्रिब्यूनल. ओके, अब हमारा राइट्स एंड ड्यूटीज ऑफ डेटा प्रिंसिपल, obtain information about process, seek correction and erasure, grievance redressal. Nowadays in Facebook, Instagram and all, I think in Facebook or Instagram also, they give you an option that who is the person you are nominating. If someone, God forbid, dies, then definitely that person will be the responsible for your account. So right to nominate a person to exercise rights in case of डेथ और इनकेपेसिटी. उनकी क्या क्या ऑब्लिगेशन है जो डेटा फिड्यूशरी है. एंटिटी डिटरमाइनिंग द पर्पस, मतलब रीजनेबल सेफ गार्ड्स, एक्यूरेसी एंड कंप्लीटनेस, इन्फॉर्म द डेटा डिजिटल डेटा प्रोटेक्शन बोर्ड जो है अफेक्टेड पर्सन इन केस ऑफ अ ब्रीच, इरेज पर्सनल डेटा एज सून एज द पर्सन हैज बीन पर्पस हैज बीन मेट. अब क्या है सिग्निफिकेंट डेटा फिड्यूशरी, कैसे, तो हर चिंटू वेबसाइट है 2 लाख. So those data fiduciaries which are big data fiduciaries like Facebook, Instagram, they are big data fiduciaries. So central government may notify data fiduciary as significant data fiduciary based on the factors such as volume and sensitivity, risk to rights of data principal, potential impact, all such thing will have additional obligations. उनको ऑफिसर अपॉइंट करना पड़ेगा. एग्जेम्पशन, इस एग्जेम्पशन को लेके वही बैलेंस्ड आंसर है. टू सो मेनी एग्जेम्पशंस आर बीन गिवन टू द एजेंसीज, ऑल सच थिंग्स. ओके, सो while processing the personal data, data fiduciary must not undertake processing that is likely to detrimental effect on well-being of a child, monitoring and all such thing. So Digital Personal Data Protection Act, you will find in Vision IAS current affairs also. I'm exactly missing the month. You will find, if you will see the how you will find it, the moment you will see which month the law was passed, and immediately you can go and locate at the Vision IAS website. In this month you will find the mention of in current affairs. Okay, जैसे कोई law है, you want to study about the law, you will type in basic information, you will get it was passed in this month. Same month current affairs, you will go and search, you will find. Okay. पब्लिक एग्जामिनेशन प्रिवेंशन ऑफ अनफेयर मीन्स 2024, इसमें क्या है. ओके, इसका रूल्स को नोटिफाई किया है. ओके, सो इट इज़ द रिस्पॉन्सिबिलिटी ऑफ द इंचार्ज पर्सन इन चार्ज ऑफ द एग्जामिनेशन. ही विल फाइल एन FIR. ओके, कमिटी टू बी कॉन्स्टिट्यूटेड इफ देर इज अ ऑल सच थिंग. बेसिक है. ओके, व्हाट डू यू मीन बाय अनफेयर मीन्स. Unfair means unauthorized access or leakage of question paper answer key. Okay, tampering with computer network. Unfair means करने का 5 years का for service provider group committing organized crime. Okay, all offenses are cognizable and they are non-bailable and non-compoundable. Cognizable मतलब police can arrest without a warrant. Non-bailable मतलब bail is not a right but the discretion of the court. And non-compoundable means compromise between victim and accused is not allowed. Okay, public examination means any organized a public exam or as notified by the central authority. Okay, so central government will notify or any public examination authority. Telecommunication Act is also important. So 5 things we have seen. भारतीय नागरिक सुरक्षा संहिता, भारतीय साक्ष्य अधिनियम, भारतीय न्याय संहिता, डिजिटल पर्सनल डेटा प्रोटेक्शन एक्ट, and public examination. Unfair, this means prevention of unfair means act. This is something which is there. In fact, rules were made first. It was act in 2024. You know, act or rules. Okay, Citizenship Act 1955, Citizenship Rules 2003, Cinematograph Act 1952, Cinematograph Rules 2024. You have what you call the IT Act. इस तरह करके rules होते हैं. Kerala Temple Authorization of Entry. So rules are made by the executive to implement the act. Okay. So we have this. ये हमने देखा. अब Telecommunication Act. It amend the law related to principles of inclusion, security and growth and responsible on Indian Telegraph Act 1885 को replace किया दोनों act को. Now we have spectrum allocation on administrative basis, all such thing. Okay, right of way, non-discriminatory and non-exclusive, what facilitating of property, all such basic thing. You know, Bharat Digital Bharat Nidhi. Okay, who has the power to, on what grounds phone can be tapped? Phone can be trapped on the ground of security of state, public order and prevention, incitement of offenses, authorization, all such thing. OTT. इसमें थोड़ा सा you also read more about the law. Cinematograph rules 2024 is important. You go and read. Okay. इंटरनेट शटडाउन पे क्या है? एक सॉफ्टवेयर फ्रीडम लॉ सेंटर है. सॉफ्टवेयर फ्रीडम लॉ सेंटर प्रिपेयर्स अ रिपोर्ट ऑन इंटरनेट शटडाउन अक्रॉस. ओके, नाउ अब गौर से सुनिए. The Indian Telegraph Act 1885, which was the principal law that empowered the Home Secretary to order phone tapping, that and Wireless Act has been replaced by this new law. The allocation of spectrum के लिए वो globally admitted principles on which the allocation of spectrum will take place has been brought in India. The right of phone tapping and other provisions, मतलब ये on what grounds phone can be tapped explicitly they have provided. So they have brought more certainty. This law is also an important law, that is why it has been incorporated. You just see. Now this internet shutdown, you know, अब इसमें केस है भाई अनुराधा भसीन केस, you know, related to Jammu and Kashmir. Supreme Court said in internet shutdown is also what you call restricting freedom of speech and expression. 19(1)(a). 19(1)(g), Ola, Uber, Swiggy, Zomato, right to practice any trade, occupation, profession or business. Then multiple aspects Supreme Court has highlighted. अब इसमें क्या है, जो सॉफ्टवेयर फ्रीडम लॉ सेंटर इंपॉर्टेंट ऑर्गेनाइजेशन है, ये इस कहा कि इंडिया में 60 इंटरनेट शटडाउन हुए 2024 में. So reasons for internet shutdown, you know what are the reason? National security, social unrest, communal riots and all, prevent cheating and security and public order. What are the provisions for internet suspension of telecom services? Rules notified under the law. Now they are notified under the new law. It provides for temporary shutdown of telecom services in grounds of public emergency. Empowers the central government to regulate the telecom services. अच्छा, नए rules में 3-member review committee will review the shutdown. Okay, so this is अच्छा यहाँ दिया ही हुआ है. अनुराधा Bhasin versus Union of India held that freedom of speech and expression is an integral part of the, and accordingly internet shutdown also has to utilize temporary. Okay, एक और कहा था doctrine of proportion, that whenever you are suspending the internet it should be for a proportional cause. For example, there is a small fight between two group of students at Old Rajendra Nagar. You cannot suspend internet because that is not that big a cause. So doctrine of proportion का मतलब, for whatever you are restricting the fundamental rights, it must be proportion to the reason why you want to achieve the same. Okay, so this is something which is there. Anuradha Bhasin case is there. Okay, so utilize for temporary, subject to judicial review, so must not be necessary, it is principle of proportionality. कोई भी any action of the state should be proportion to the cause for which it has been imposed. This is a thumb rule, doctrine of proportionality. For example, there is a bicycle theft in the colony. You will not check everybody's mobile phone. क्यों? Because for a bicycle theft, invasion of privacy is too big. So there will always be, we say that in arrest only necessary, what is the minimum necessary force that can be exercised by the police. So that is something which is there, that is doctrine of proportionality. ठीक है? In sub laws में what you need to do, there is a likelihood that there will be at least one question from all the laws that we have discussed. Now it is up to you not to miss that question. Okay, so you will go through these laws, not going too deep, but basic aspects of the law, and they will be framing a question. They may ask 2 questions also, because this year, not every year, but this year actually there are too many important laws, especially you have Bharatiya Nyay Sanhita and Nagrik Suraksha Sanhita and Sakshya Adhiniyam. I have been taking current affairs for past 3-4 years. This year relatively there are more laws, so I'm expecting a question in prelims from the laws also. So go through, you will have. Now Consumer Protection Act में इसमें एक मामला था, क्या वकील, can a advocate be held responsible for lack of services? इसमें सुप्रीम कोर्ट ने बोला नहीं. can an advocate be what you call held responsible for lack of services? So in the Supreme Court overruled National Consumer Disputes Redressal Commission judgment, which ruled that services rendered by lawyers are also covered under Consumer Protection Act. कोर्ट ने कहा नहीं। तो ये एक्ट क्या है भाई? इट वाज रिप्लेस्ड की फीचर्स ऑफ 2019 एक्ट क्या है? ब्रॉडर, अब ये क्वेश्चन एक यूपीएससी ने पूछा है पहले, व्हाट आर द राइट्स ऑफ अ कंज्यूमर अंडर कंज्यूमर प्रोटेक्शन एक्ट, कैन यू taste or not? Okay, so this question has been asked before. Consumer, see, all those laws they will be asking which has a daily, day to day. For example, if they are asking a question on FSSAI, okay, so ये question पूछेंगे क्योंकि when you will be posted as a civil servant, you will get to know कि there is a contaminated food, that is, so basic aspect, what are the regulatory mechanism and all those things you should follow. So Consumer Protection Act में consumer का definition क्या है? Who buys goods service also through online, or it does not include a person who obtains such good for resale. For example, you are anybody who is buying a good for resale, then he is not a consumer. Enables Central Consumer Protection Council है, advisory council है, consumer right, you see always जनहित में जारी. Okay, so that is it in minister in charge of the Department of Consumer. Established Consumer Protection Authority है, consists of chief commissioner, investigative wing है इनके पास, redressal mechanism, mediation cell है, national commission for each. These are pure fact. Product liability action, penalties for misleading. अब surrogate advertisement, you know these things, advertisement के अलग अलग type, जैसे for example alcohol advertisement is banned, so there will be club soda. Okay, so club soda, मतलब advertisement, everyone knows that the company also produces. For example, there was a World Cup, one of the prominent cigarette seller sponsored a World Cup. Okay, so we know that the cigarette advertisement is banned in India. So but अगर वही company, for example any XYZ, without naming, X company manufactures and produces alcohol, and the same X company also sells water, so वो उसी नाम से अपना X water खरीदें, through day and night there will be what you call campaign. Or club soda, baking soda you say, नहीं, club soda you say, so club sodas actually what it is about, so surrogate advertisement. इस तरह basic term जो है वो you must know. Okay, that what is it, what you call, so imprisonment वगैरह, misleading advertisement, right to be safety, choose to hurt, seek redressal, related news. Now advertisement on prohibition of advertisement, जैसे lawyer को advertisement allowed नहीं है, solicit नहीं कर सकते हैं client को. Okay, reasons for advisory, all such things are there. Gambling is a state subject, entry 34, entry 62 for the purpose of taxation. इसीलिए when you those all these online betting sites and all gaming sites, or many a time they say whether you are logging from the state of Telangana, then they will not allow, because those states have not allowed. Okay, so Ministry of, I don't know what is the present status, but it used to be Ministry of Information and Broadcasting advise. अब चूंकि एडवर्टाइजिंग की बात हो गई, what is the, and I told you copyright, patent, you have intellectual property, all such things, what are the various kinds of advertisement and all such things. Okay, this is something which is there. Now ये तो important है, Foreign Contribution Regulation Act. Foreign Contribution Regulation Act is in news because many of the non-government organizations, FCRA ने बहुत tight, FCRA was amended, that many abhi, in fact I see people who are running NGOs, when they open bank accounts, current bank accounts, a lot of document is required. So for usually you will see Ministry of Home Affairs cancelled the license of many of the NGOs, which is Kundakulam, that nuclear power plant. It was later found that some NGOs were fueled by the outside or related to the activities related to conversion and all. So the FCRA was amended कि जो NGOs हैं who are receiving money from outside, तो उनको थोड़ा टाइट किया जाए, so that they are also, their money is not being used for the purpose other than what it has been, what you call, transferred to India. If we see, समझ रहे हैं ना? सो बेसिकली इसका मेन जो है इसी के लिए न्यूज़ में था कि फॉरेन कंट्रीब्यूशन रेगुलेशन एक्ट they have amended so that these NGOs cannot use the money for the purpose other than, because there were some complaints that conversion activities or some protest against the nuclear plant on the ground of environment. Actually it was to hinder India's growth and development. So to that there, so these NGOs there has been more strict rules. क्या है भाई, मिनिस्ट्री ने diversion of foreign funds for carrying out anti development activities or inciting malicious protest. Okay, so FCRA is implemented by Home Ministry 2020 में, तो ये कई बार we have discussed this. This has amendment was major prior permission to receive foreign funds through registration with mandatory आधार. हर ऑफिस बियरर को अपना आधार देना है. ओके, सो कौन कौन लोग FCRA में पैसा नहीं ले सकते हैं? कैंडिडेट्स फॉर elections, judges and government servants, journalists and newspaper, member of legislature and office bearers and organizations of a political nature. In fact, if you will open Zerodha or किसी भी mutual fund या equity secondary market में, if you will open an account, they will ask, are you exposed to politics? They will ask whether you are related, all such things. Designated FCRA account in such branches of State Bank of India. No, जिस account में you have designated, you can receive money only in that account. After 5 years you are will renew the expire. अब ये important है कि maximum limit for administrative expense is 20%. For example, an NGO received 100 crore rupees. 80 crore rupees was spent on seminar on poverty, and 20 crore was spent on eradicating poverty. 80 crore was paying on salary of office bearers of NGO, and 20 crore was paid on what you call the purpose of NGO. So administrative expense cannot increase 20%, उससे 80%. So जो भी पैसा आया 20% can be maximum limit of 20% for administrative expense. कम कुछ changes, क्या क्या major changes ये छोड़िए मैं बताता हूँ. First important changes हुआ कि all the office bearers will provide their Aadhaar card. Okay. Second important thing, every 5 years you have to go for renewal. Third important thing, you have to open a designated account. उसी account में पैसा आएगा. Fourth important thing, that administrative expense में जो पैसा आया, you will spend only 20%. इस तरह करके they have made the norms tight so that these NGOs do not use the fund for anti-development and related activity. अब ये Post Office Act 2023. Okay. Usually they sometimes surprise, you know, Indian Postal Service भी है, रफ़ी अहमद केदवई नेशनल पोस्टल एकेडमी है, कहाँ है? गाजियाबाद. So Indian Postal is a small service. Indian Postal Service है, if you group A में, if you get down the rank, Indian Corporate Law Service, Indian Information Service, Indian Postal Service, Indian Defence State Service, Indian Defence Account Service, Indian Civil Account Service, Indian Audit and Account Service. Getting my point? So there are many Assistant Commissioner, RPF, there are many Group A services other than Indian Foreign Service, Indian Revenue Service, Income Tax, Custom and Indirect, Indian Railway Management Service. Okay. So now you have Post Office Act 2023, जिसने previous law को replace किया, Indian Post Office Act 1998. Director General of Post Office, some of you will get Indian Postal Service. Indian Postal Service is a service जिसमें first you will become Superintendent of Post, SP Post, then you will go to other Director General or Postmaster General of the state and all. Okay. So Director General of Postal Services will be appointed to head. DJ will have the power, these powers, power to intercept postal articles. कोई भी ऐसा envelope, कोई भी ऐसा inland letter which you have said, government can intercept an article transmitted through India Post on specified ground. अगर उनको लगता है, they will open and they will check exemptions. Post Office will not incur liability with regard to its service except such liability as regard what you call as provided by the Post Office. There are no penal provisions. So first Post Office and such, first Post Fort William and all. Okay. Now these are the bodies. ये तो मैं ऐसे ही बताऊंगा आपको. Okay. Now National Human Rights Commission क्या है भाई? सबसे पहले National Human Rights Commission was in news. Okay. Okay. Now first thing, इससे पहले you will also study United Nations Human Rights. Getting my to that you need to study. Second important thing, Protection of Human Rights Act 1993 led to the establishment of National Human Rights Commission. Third important thing, जो 5 years back major changes was done. Only former Chief Justice of India can become the chairperson of National Human Rights Commission. Law was amended क्योंकि government के पास बहुत restricted numbers. There are 1 or 2 sittings. CGI can also become, but usually an outgoing or a retired CGI was made. So only few CGIs was there. Government was having a limited option. So they amended the law कि नहीं भाई, former Chief Justice of India or a retired judge can also become the chairperson of National Human Rights Commission. Justice Arun Mishra was the first person to be appointed after that amendment. He was not the former CJI but judge of the सुप्रीम कोर्ट. अब इसमें क्या है, प्रोटेक्शन ऑफ ह्यूमन राइट्स एक्ट 1993 के कुछ मेजर प्रोविजंस है. व्हाट आर द फंक्शंस, दे विल प्रमोट ह्यूमन राइट्स लिटरेसी, दे कैन विजिट द जेल एंड डिटेंशन centers, they can study the international treaties and what you call conventions related to human rights, they will suggest the government on improvement related to prisons and all such things they can visit. Bilkis Bano case, any case related to life or personal liberty going on in the country, National Human Rights Commission can become a party. कोई भी केस इंडिया में रिलेटेड टू लाइफ और पर्सनल लिबर्टी जो देश में चल रहा है, नेशनल ह्यूमन राइट्स कमीशन कैन फाइल एन इंटरवीनिंग पिटिशन. ओके, सो बिल्किस बानो केस वाज ट्रांसफर्ड फ्रॉम गुजरात टू महाराष्ट्र ऑन अ पिटिशन फाइल्ड बाय नेशनल ह्यूमन rights commission in the Supreme Court. So National Human Rights Commission can become a party to any case related to life or personal liberty, all such thing. Next important thing that National Human Rights Commission को एक former Chief Justice of India ने, former judge of Supreme Court said that it is the toothless tiger. क्यों, why it was called, जैसे CBI was called a caged parrot, उसी तरह it was called toothless tiger because of two major things. पहला, it can only take up human rights violation that have occurred in last 1 year. वो सारे ह्यूमन राइट वायलेशन जो पिछले 1 साल में हुए हैं, सिर्फ उसी को ही आप टेक ओवर कर सकते हैं. दूसरा, any human rights violation that is done by the members of armed forces, you can entertain a complaint but you will not conduct an inquiry, you will seek a report from the central government, whatever report they give you will act on that, and their role is advisory in nature. So these are the two reasons why human right was called as a toothless tiger. As in the first class only I said that who are the ex officio chairperson of National Human Rights Commission, जितने भी all the commissions to safeguard the interest of vulnerable section, जो भी आपके दिमाग में whatever can come to your mind, उस सब के chairperson are the ex officio members of NHRC, National Commission for Women, National Commission for Minorities, National Commission for Scheduled Caste, National Commission for Scheduled Tribe, National Commission for Backward Classes, Chief Commissioner for Persons with Disabilities and National Commission for Protection of Child Rights. इन सब के तो चेयरपर्सन होंगे, दे विल बी द एक्स ऑफिशियो मेंबर्स ऑफ NHRC. 3 अभी ऐड हुए हैं रिसेंटली. ओके, दैट इज नेशनल कमीशन फॉर बैकवर्ड क्लासेस आफ्टर इट बिकेम अ कॉन्स्टिट्यूशनल बॉडी, चीफ कमिश्नर फॉर पर्सन्स विद डिसेबिलिटीज एंड नेशनल कमीशन फॉर प्रोटेक्शन ऑफ चाइल्ड राइट्स. सो नेशनल कमीशन फॉर माइनॉरिटीज, SC ST बैकवर्ड क्लासेस, जितने भी बॉडीज हैं उसके जो चेयरपर्सन है दे आर एक्स ऑफिशियो मेंबर्स ऑफ नेशनल ह्यूमन राइट्स कमीशन. क्योंकि ह्यूमन राइट्स वायलेशन का मोस्ट लाइकली जो होगा दैट विल बी अगेन दीज मेंबर्स. ये ऑल दीज प्रोविजंस आर रिलेटेड टू नेशनल. अब इसमें यूनाइटेड नेशंस ह्यूमन राइट्स अब कमिटी, इस सब का थोड़ा सा बेसिक यू शुड सी. अब ये है, ये देखिए रिसेंटली, यही मैं आने वाला था, रिसेंटली यूनाइटेड नेशंस लिंक्ड ग्लोबल अलायंस ऑफ नेशनल ह्यूमन, इंडिया का ऐसा नहीं, ये पहले भी हो चुका है. आवर नेशनल ह्यूमन राइट्स कमीशन को कई बार एक्रेडिशन से हटा देते हैं फिर ले आते हैं. इट इज ऑल्सो हैपेंड, दिस वाज फॉर द सेकेंड टाइम इन अ रो. नेशनल ह्यूमन राइट्स कमीशन को इंटरनेशनल बॉडी ने रिकॉग्नाइज नहीं किया, डी एक्रेडिट किया. क्यों भाई? So NHRC got A status in 2016 also it was deferred by a year. I told you after it received A rating. In 2023 accreditation of NHRCI, National Human Rights Commission of India, was deferred. Up the current accreditation by GANHRI, that is Global Alliance of National Human Rights Institutions, jitne bhi hain, was deferred by what you call is deferred due to lack of diversity in staff and leadership. अब ये क्या है भाई? ग्लोबल अलायंस ऑफ ऑल द नेशनल ह्यूमन राइट्स कमीशंस, ओके, फॉर द प्रोटेक्शन एंड प्रोटेक्शन ऑफ ह्यूमन राइट्स. 120 मेंबर्स है, सब कमिटी ऑन एक्रेडिशन, ऑल सच थिंग. हमारा जो NHRC है वो 1993 का एक्ट है, 2019 में मेजर अमेंडमेंट जो मैंने कहा, आई सेड न्यू दिल्ली इज द हेडक्वार्टर, व्हाट प्रोटेक्शन ऑफ ह्यूमन राइट्स एक्ट डिफाइन. हाँ, ये इंपॉर्टेंट है. व्हाट इज अ राइट? व्हाट इज अ राइट? claims of an, okay, rights. Suniye, I know you will give many answers and all of them are correct. In simple, rights are legally protected interests. Those rights are those interests which are legally protected. It comes from the legal maxim जो दिखाए थे first दिन, you be first day I showed you, you be just ibi remedium. Where there is a right, there is a where there is a right, ये बहुत सबसे ओल्ड मैक्सिम है, वेयर देर इज अ राइट देर इज अ रेमेडी. सो राइट्स आर लीगली प्रोटेक्टेड इंटरेस्ट. अब आते हैं राइट पे, बिकॉज आई नो यू हैव मेनी डाउट रिलेटेड टू दिस. अब लेट्स टेक 5 काइंड्स ऑफ राइट्स. फर्स्ट यू विल सी स्टैट्यूटरी राइट्स, then you will see constitutional rights, then you will see fundamental rights, then you will see natural rights, and then you will see human rights. For example, in protection of human rights, अब समझते हैं. Usually any right that is mentioned in the, when we study jurisprudence, any right that is coming from the constitution is a constitutional right. So technically speaking, fundamental rights are also constitutional rights. But in India, when we use the term constitutional rights, we are referring to those rights that are inside the constitution but outside part 3 of the constitution. Listen to me carefully. From article 1 to article 395 of the constitution, there are rights that are in part 3 of the constitution, from article 12 to article 35 of the constitution. So constitutional rights means that right that emanate from the constitution. Par Bharat mein, because there is a difference between constitution, fundamental rights and other rights, so those rights that are in part 3 of the constitution, from article 12 to article 35, are called as fundamental rights. And those rights which are outside part 3 but inside the constitution, that जैसे article 326 right to vote, जैसे article 300 capital letter A, which all of us know, that is, no person shall be deprived of his property save by the authority of law. So constitutional rights are those rights which are inside the constitution but outside part 3, but in general fundamental rights are also constitutional right. Third point, those rights which emanate from a statute. जैसे when you will download महात्मा गांधी नेशनल रूरल एम्प्लॉयमेंट गारंटी एक्ट, उसमें आपको मिलेगा 100 days of unskilled manual labor to every rural household. So that 100 days of unskilled manual labor is being guaranteed by a law. So it is becoming a statutory right. Next, two major confusion is there. One is natural right and other is human right. Ab human right. Any right, see, the entire concept of right has originated from the work of John Stuart Mill and Rousseau and Locke. Three people are prominent. John Stuart Mill has written an essay in defense of liberty. गौर से सुनिए. When the state, after the Treaty of Westphalia, the concept of state started being originated. Then some scholars started saying कि हमें आपसे जरूरत नहीं है right की. We don't need right from the legislature. By virtue of being born in human family, certain rights that accrue to you, that rights will be given to you as a natural right. Now what is the difference between natural, although I am broadly, you will find these things in, if you have pol science and sociology as an optional, you will understand. Now listen to me. ये पूरा movement था कि we don't, the legislature will not give us the right to sleep. The legislature will not give us the right to speak. The legislature will not give us the right to practice any religion. The legislature will not give us the right to live. Those rights which accrue to us as members of human family, and the same which also accrue to animals, they are ordained by nature or by God, are natural rights. They are mostly negative rights. They are mostly negative rights. गौर से सुनिए कि when will you sleep, state will not interfere. What will you speak, state will not interfere. By virtue of being born in human family, those rights that accrue to you are natural rights. अब ये these rights are also available to other species. अब one scholar has beautifully defined what is the difference between natural right and human right. गौर से सुनिए. Natural rights are mostly negative in nature. वो basic चीज that is required to live is natural right. But you say as so human rights also include something positive. जैसे for example, the state will not kill you. The state will not kill you. But you also require human right. What is human right? So, जैसे कि for example, a person will, no person shall be deprived of his life or personal liberty except through a procedure established by law. No person shall be deprived of his life or personal liberty except through a procedure established by law. यानी किसी भी इंसान से उसकी जिंदगी या उसकी लिबर्टी नहीं छीनी जा सकती except through a procedure. अब गॉड से मेरी बात सुनिए, इसमें 5-7 minutes I'll take. No, because time and again UPSC is asking question on rights and trapping the student. No person shall be deprived of his life or personal liberty except through a procedure established by law. Now Dadabhai Naroji in his book Poverty and Un-British Rule in India, he writes कि हाँ, Britishers always claim that we have brought public order in the country. अंग्रेज हमेशा कहते थे कि आपके यहाँ तो लॉ एंड ऑर्डर था नहीं, हमने इंडियन पिनल कोड ड्राफ्ट किया और हमने लॉ एंड ऑर्डर, we have brought public order. He said, yes, you have brought public order, but poor man is allowed to starve in peace. यानी no person shall be deprived of his life or personal liberty except through a procedure established by law. किसी भी इंसान को उसकी जिंदगी और उसकी लिबर्टी से वंचित नहीं किया जाएगा जबकि ऐसा लॉ के द्वारा स्थापित किया गया हो. On 20th of March 2020, 4 people were hanged in heinous Nirbhaya case. Okay, 4 people were hanged on 20th of March 2020, 5 days before the lockdown. Okay, 4 or 5 days before the lockdown, they were hanged. Now, no person shall be deprived of his life, but except through a procedure. So, they were hanged through a procedure established by law. So, किसी भी इंसान की जिंदगी नहीं लेना. No, that is a negative aspect of the right, that nobody will be taken up. But is that enough? So, to live a life, you also require education. Without education, there is hardly difference between an animal behavior and a human behavior. So why do we, abhi I was asked, I was taking a batch at GTP Nagar, I was doing article 21A. I asked, why do we need education? One student sir said ki sir, we need to, because we need to earn money. We need to earn money. So although he was, what he said was theek hai chaliye, but we all know ki why do morality or ethics to theek hai, that is also a thing. But most importantly, we need education, otherwise we will not be able to understand what is going on. You are traveling from here to what you call Rajiv Chowk. Rajiv Chowk, you will find the billboards on both the side. If you are not educated, you will not be able to understand what is written. You receive a WhatsApp message, you will ask a friend of yours to interpret. So education is, life is incomplete without education. From filling a form, from knowing your right, from taking admission, from getting food and civil supplies, from knowing your fundamental rights, everything you require education. Otherwise life is incomplete without education. And this is the reason why after article 21 and before article 22, exactly it was added after right to life, because Supreme Court in Mohini Jan versus State of Karnataka and Unni Krishnan versus State of AP, 2 cases Supreme Court has ruled that right to life include education. So natural rights are those rights which are ordained to human by virtue of being born in human family by the nature. उससे थोड़ा बढ़कर certain positive rights which are required for complete realization of human potential, that is human right. Getting my point? So human rights is natural right plus certain other positive rights is human right. Now in Protection of Human Rights Act 1993, National Human Rights what you call human right has been defined. If they will not define human right, it will create a confusion. Why? For example, you are eating paratha at Old Rajendra Nagar. Somebody takes one paratha of yours. You will say it is a violation of human rights. A menu in the hostel says that on Wednesday there will be a non-vegetarian meal, but on Wednesday, due to some unavoidable reasons, they provided a vegetarian meal. So somebody will say this is a violation of human rights. So if you will keep human right as an open-ended term, अगर आप उसको open-ended रखिएगा, तो everybody will start moving National Human Rights Commission and say that this is a violation of ह्यूमन. इसीलिए उन्होंने ह्यूमन राइट्स को प्रोटेक्शन ऑफ ह्यूमन राइट्स एक्ट 1993 में डिफाइन किया है. ह्यूमन राइट्स आर दोज राइट्स दैट आर रिलेटेड टू लाइफ, लिबर्टी और डिग्निटी ऑफ एन इंडिविजुअल, either guaranteed by the constitution or by an international covenant or international agreement which is enforceable by courts in India. You feel it is a human right, I feel it is a human right, or he feels it is a human right, or he feels it is a human right. नहीं. Only those Protection of Human Rights Act 1993, National Human Rights Commission सिर्फ उन शिकायतों को entertain करेगा. It will entertain only those complaints that are related to life, liberty or dignity of an individual which is guaranteed by the Constitution. or any international covenant that is enforceable in India. जैसे you have UN Convention on Elimination of All Forms of Discrimination against Women, UN Convention against Corruption. You have ILO 2 Convention number 184. India has signed 2 out of 8 conventions only we have signed. UN Convention on Refugees 1951 we have not signed. Additional Protocol of 1967 we have not signed. कुछ कन्वेंशन हमने साइन किया है, कुछ कन्वेंशन हमने साइन नहीं किया है. सो व्हाट इज इंपॉर्टेंट कि नेचुरल राइट, दोज राइट्स विच एक्रू, जिसके लिए आपको राज्य की जरूरत नहीं है, दोज राइट्स दैट एक्रू टू यू नॉट बाय द लेजिस्लेचर, जस्ट बिकॉज वी आर बोर्न एज अ ह्यूमन बीइंग. अब इस नेचुरल राइट से थोड़ा हट के सम मोर पॉजिटिव राइट टू रियलाइज द ट्रू पोटेंशियल ऑफ ह्यूमन, यू हैव एजुकेशन. So with some positive rights you have human rights. So you have natural right, you have human right, you have statutory right, you have constitutional right, and you have what? Up one question was asked that right to property is a legal right. Rights are legally protected interests. So constitutional rights are also legal rights, because rights ultimately are those interests which are legally protected. Although UPSC only 2 questions UPSC is left to be asked. One question they will ask that fundamental rights are constitutional rights. Today or tomorrow they will ask this question, fundamental right. 2 questions. Question number 86 2017 series A. Question number 86 2017 series A, they asked the question right to vote. Okay, and option was right to vote is a constitutional right. But I told you in Representation of People Act, अगर section 62 देखे तो सीधा लिखा हुआ है right to vote. अगर आरपीए सेक्शन 62 को देखे, सेक्शन 62 इज राइट टू वोट. इसको ओके, just so if we see this provision with respect to this, ऐसे ही okay. So if we have section 62 of the Representation of People Act. Okay. So ये क्या लिखा हुआ है सेक्शन 62 में? Right. So right to vote तो भाई 3 जगह हो गया. Right to vote is explicitly mentioned in section 62 of the Representation of People Act 1951. In Article 326 of the Constitution, it is not explicitly mentioned. I think I discussed one day. It is not mentioned. Association for Democratic Reforms and many other cases, Supreme Court ruled that freedom of speech and expression also includes right to vote. So Article 19(1)(a में it is an implicit right. Article 326 में without mentioning the right to vote, the right to vote is being given as a constitutional right. And it is also provided explicitly in Section 62 of the RPA 1951. अब यूपीएससी ने क्वेश्चन पूछा, राइट टू वोट इज अ स्टैट्यूटरी राइट, फंडामेंटल राइट, कॉन्स्टिट्यूशनल राइट, एंड सम अदर ऑप्शन दे मे हैव गिवन. सो द करेक्ट आंसर विच दे रिलीज वाज constitutional right. And this answer key, although many students come to me from School of Theatrologics, a big school in India, okay, so they come to me, वो आते हैं, what getting my point. So unnecessary debate में हमें नहीं पढ़ना है, because I know कि qualify, जिसको सुन लीजिए, जिसको क्वालिफाई करना है उसको अननेसेसरी इंफॉर्मेशन आएगा तो वो बोलेगा भाई मेरे पास आना ही नहीं. हाँ, जिसको माहौल बनाना है ओआरएन में, आई विल, अच्छा यू हैव अ डाउट अबाउट अकबर, आई विल से ही यूज्ड टू ईट खिचड़ी ऑन मंडे, लाइक्ड दलिया ऑन ट्यूसडे. गेटिंग माय पॉइंट, वो मैं रोज डील करता हूं. ओके, कसम से यू आस्क 90 मोस्ट ऑफ द टाइम, आई सी द फेस, आई अंडरस्टैंड व्हाट इज द क्वेश्चन एंड व्हाट इज गोइंग ऑन इन द माइंड. ओके, पहले ही चेहरा ही देख के मैं समझ जाता हूं कि इस मर्ज की दवा क्या है. ओके, नाउ दिस इज, नाउ लिसन. सो सबसे पहले दिस इज वेरी इंपॉर्टेंट. व्हाट इज द डेफिनेशन ऑफ ह्यूमन राइट्स एज पर प्रोटेक्शन ऑफ ह्यूमन राइट्स एक्ट? प्रोटेक्शन ऑफ ह्यूमन राइट्स कहता है राइट्स रिलेटिंग टू लाइफ, लिबर्टी, इक्वालिटी एंड डिग्निटी ऑफ इंडिविजुअल, ईदर गारंटीड बाय द कॉन्स्टिट्यूशन और एन इंटरनेशनल कोवेनेंट विच आर इन्फोर्सिएबल बाय कोर्ट्स इन इंडिया. हम और आप मानेंगे उससे ह्यूमन राइट नहीं होगा. दिस दे हैव टेकन फ्रॉम सेक्शन 2 ऑफ प्रोटेक्शन ऑफ ह्यूमन राइट्स एक्ट 1993. अपॉइंटमेंट एक प्रेसिडेंट करेंगे, हेडेड बाय अ प्राइम मिनिस्टर विल हेड अ कमिटी, दिस बेसिक चेयरपर्सन टर्म्स एंड ऑल सच थिंग, रिमूवल एंड ऑल सच थिंग. पावर, हाँ ये आपको बता देते हैं, नेशनल कमीशन फॉर बैकवर्ड क्लासेस, नेशनल कमीशन फॉर शेड्यूल्ड कास्ट, शेड्यूल्ड ट्राइब एंड नेशनल ह्यूमन राइट्स कमीशन, ऑल ऑफ देम हैव पावर्स ऑफ अ सिविल कोड जो आपने कई बार पढ़ा होगा. रीजन बीइंग सिंपल, इफ दे विल नॉट हैव द पावर ऑफ सिविल कोड, हाउ विल दे कॉल समवन? किसी को बुला नहीं सकते हैं. सो समनिंग पावर्स, इन्फोर्सिंग अटेंडेंस, आस्किंग द, फॉर एग्जांपल सेड व्हाट इज योर नेम, यू सेड a to the a plus b the whole square. So the NHRC will say, okay, give me this on FE David. For saying something statement is not wrong, but if you'll give that on FE David, it is wrong. Okay. So inquire into human rights violations, intervene, visit any jail. ये सारे basic points हैं. Some I have added. They can take into what? हाँ, 7 deemed members मैंने बताया ही था. National Commission for Minorities, Backward Classes, Chief Commissioner for Person with Disabilities, SC, ST and Protection of Child Rights, and National Commission for Women. मैंने कहा था ये जितने भी chairperson हैं, all of them are ex officio members of. ex officio क्या हुआ? जैसे by virtue of one office you get the other. जैसे राज्यसभा का जो, हाँ, that is, हाँ, okay, chairperson of राज्यसभा, vice president is the chairperson of राज्यसभा. और ये तो 7th क्लास का बच्चा भी लिखेगा. प्राइम मिनिस्टर इज द चेयरपर्सन ऑफ नीति आयोग 1 जनवरी 2015. और हाँ, ओके, वेरी गुड. द चीफ जस्टिस ऑफ इंडिया इज द एक्स ऑफिशियो. नालसा का क्या, वही वर्ड चाहिए मुझे. अभी आपने बोला चेयरपर्सन, जो बिल्कुल गलत है. पेट्रन एंड चीफ इज देयर, एंड चीफ जस्टिस ऑफ इंडिया इज द, ही इज राइट, बट थोड़ा सा यहीं पे सावधानी हटी, दुर्घटना घटी. नेशनल लीगल सर्विस अथॉरिटी, चीफ जस्टिस ऑफ इंडिया इज द पेट्रन एंड चीफ. वन ऑफ द सिटिंग और रिटायर्ड जजेस ऑफ सुप्रीम कोर्ट शैल बी द एग्जीक्यूटिव chairman of what you call National Legal Services Authority, executive chairman. So there is an executive chairman. You guys, uske baad you also go and see Supreme Court Legal Services Committee. Although he is right, patron and chief matlab oversee the implementation, but actually work will be done by executive chairman. बहुत basic है, ऐसा कुछ नहीं है, rocket science है. In fact, most of the things are absolutely easy. You will, if you will, it is only because you have not studied. Why you have not studied? 2 reasons. One, you don't have time, because you are already doing so many things. If you will study, you will do. क्योंकि भाई time का तो challenge है, of course that is there. और मस्ती भी थोड़ी can be a reason, but most of the things are ultimately very easy. कुछ भी ऐसा नहीं है. Okay. What so recently Central Bureau of Investigation, Constitution में mention है? हाँ? It is a constitutional या कुछ इससे related? कुछ भी नहीं मेंशन है. सीबीआई इज नॉट अ कॉन्स्टिट्यूशनल बॉडी, ये तो 7th क्लास का क्वेश्चन है. बट एनीथिंग रिलेटेड टू व्हाट यू कॉल लेट्स सी एंट्री 8 ऑफ द यूनियन लिस्ट. एंट्री 8 ऑफ द यूनियन लिस्ट देखा जाए. 7th शेड्यूल, Central Bureau of Intelligence and Investigation mentioned in the entry 8 of the Union. अब ये जवाब सही है. I am not concerned with the fact. Fact तो I am concerned with the understanding. Fact का क्या है? Fact तो they will change the fact. So on all matters, now listen to me carefully. Undoubtedly CBI, all of you are absolutely correct. CBI is neither a constitutional body nor a statutory body. इसमें कोई डिबेट नहीं है. CBI established under powers emanating from Delhi Special Police Establishment Act. But who is giving power to the Union Parliament to enact Delhi Special Police Establishment Act? On all matters related to intelligence and investigation. What is CBI? क्या है CBI? Federal FBI, Federal Bureau of मतलब the American federal government's agency of investigation is FBI. The Indian central government's agency of investigation is CBI. But from where the center gets the power to make laws on matters of intelligence and from where the Delhi Special Police established. So there is an entry, Central Bureau for Intelligence as well as Investigation. You are getting my point. So undoubtedly CBI is not a constitutional statutory body. It is an executive body, Santhanam committee and all those things. But the Union Parliament has the power to make laws on all matters related to Central Bureau of Intelligence and now listen. कुछ बेसिक कंफ्यूजन. पहला पॉइंट, एनीथिंग दैट इज मेंशन्ड इन द यूएन लिस्ट इज नॉट अ व्हाट यू कॉल इज नॉट अ बॉडी. यहाँ फॉरेस्ट मेंशन है, फॉरेस्ट इज नॉट अ कॉन्स्टिट्यूशनल बॉडी. एजुकेशन मेंशन है, तो एजुकेशन इज नॉट अ constitutional body. Anything that is mentioned in a state list, there can be a ministry at the center also. ये मैंने already I have said, I am again saying, agriculture is an entry in the state list. Agriculture is an entry in the state list. There is a ministry of agriculture. Public health is an entry in state list. There is a ministry of health. Corporation, cooperative is a pure entry in the state list, but there is a ministry of corporation, July 2021, Sehkar se Samriddhi. So having a ministry, having a entry in the state list, that doesn't mean there will be no ministry in the center. Now please understand what is this list. ये list सिर्फ ये कहता है कि on these matters the law can be made by the parliament. It doesn't mean that atomic energy is also a constitutional body. इन मसलों से जुड़े हुए मामलों पर संसद लॉ बना सकती है. On these matters, the parliament makes a law. So the mere mention of Central Bureau of Intelligence and Investigation will not make CBI a constitutional body. But yes, the Union Parliament is empowered to make laws on those matters related to intelligence and investigation by a bureau which will be of the center. So tomorrow, if central government wants to give constitutional status, that is too much, at least statutory status, then it cannot be stopped from doing the same. Only thing is, then there will be a harmonious construction, there will be a conflict क्योंकि CRPC में जो police powers है, that is given to the state, that is public order, land and police is with the state. To what extent that is the case that is going on, that you all know, you have read so many times कि भाई I can download the law also, but it takes a bit of time. Okay. So अब ये क्या है कि State of West Bengal versus Union of India, Article 131 के तहत सुप्रीम कोर्ट हैज अग्रीड टू हियर अ केस. सिंपल वेस्ट बंगाल का लॉजिक है. दिल्ली स्पेशल पुलिस एस्टैब्लिशमेंट एक्ट 1946 सेज whenever an agency of the union will function, you need to take the consent of the state, which you have heard 100 times. Now many agencies of the union which are investigating in the state, around 10 states have withdrawn the general consent. They have, with whatever number of states they have withdrawn the general consent, still the CBI is registering a case. Now listen, as because public order falls within the domain of the state, because law you have policing is in the domain of the state, so if an agency of the union investigates in the state, you have to take the permission of the state. Because many states had given general consent ki don't come to us for every case, you just, there is a general consent that is given, because in last 5 years many states one by one have withdrawn the consent, that you come to us case by case. Still CBI is filing cases. That is why West Bengal has moved Supreme Court ki although we have withdrawn the general consent given to Central Bureau of Investigation, if it is involving in the arrest and all those things, it is a direct encroachment on public order and police, which falls within the domain of the state. So this will be decided under Article 131 of the Constitution, that is the exclusive original jurisdiction of Supreme Court. So Supreme State of West Bengal upheld the maintainability. पहले तो ये सवाल था कि क्या इसको सुप्रीम कोर्ट 131 में एक्सेप्ट कर सकता है कि नहीं, whether state Supreme Court can accept or not. So maintainability of West Bengal suit against union over registration and investigation of cases by CBI. अच्छा यहाँ लिखा ही हुआ है filed under 131. I literally have not read this. Okay, so it is 131. So ये क्वेश्चन आया कि accused union of the constitutional overreach and violation of federalism, वो सब तो ठीक है, इट्स मेन पॉइंट है. Article 131 तो you know, dispute between center and state. CBI established on the recommendation of Santhanam Committee, Ministry of Non-Statutory, Non-Constitutional बॉडी, प्रीमियस इन्वेस्टिगेटिव एजेंसी, इम्पार्शियलिटी, ये तो उनकी वेबसाइट से है. कॉम्बैटिंग करप्शन, डायरेक्टर, यू नो द सीबीआई चीफ, प्राइम मिनिस्टर, लीडर ऑफ opposition and Chief Justice of India, and to promulgated 2 ordinances. Tenures of directors of CBI can be extended up to 5 years. All these things are there. CBI does not require permission. अब इस पे section 6 बहुत easy law है. Before every case you have to take permission. They have withdrawn the general consent. Still CBI is registering the FIR. So all these matters are with respect to that. Okay. Now with respect to, you have section 6 of the Delhi Special Police Establishment Act, all such thing. Okay. Now we have Lokpal. लोकपाल, यू नो, ये सब तो एकदम इजी है. लोकपाल एंड लोकायुक्त एक्ट है 2013. सबसे पहले कल मैंने बताया था ना लोकपाल पे, डायरेक्टर ऑफ इंक्वायरी प्रोसिक्यूशन. नाउ लिसन, लोकपाल जो है भाई, देयर वाज अ डिमांड ऑफ लोकपाल बिकॉज इट इज एन ओम्बड्समैन, इट इज एन ओम्बड्समैन. विथ रिस्पेक्ट टू ओम्बड्समैन कंप्लेन, अब व्हाट, सबसे पहले तो ये समझिए व्हाट इज डिफरेंट, व्हाई लोकपाल वाज रिक्वायर्ड. क्यों लोकपाल? वी ऑलरेडी हैड सेंट्रल ब्यूरो ऑफ इन्वेस्टिगेशन एंड सेंट्रल विजिलेंस कमीशन. लोकपाल की क्यों? सबसे पहले सेंट्रल ब्यूरो ऑफ इन्वेस्टिगेशन इज जस्ट एन इन्वेस्टिगेटिव बॉडी. अब सेंट्रल ब्यूरो ऑफ इन्वेस्टिगेशन अंडर द प्रिवेंशन ऑफ करप्शन एक्ट देयर आर स्पेशल कोर्ट्स वेयर दे विल गेट द पर्सन प्रोसिक्यूटेड. व्हाट वर द लिमिटेशंस ऑफ सीवीसी? नाउ आई वांट यू टू से कि क्यों सीवीसी एनफ नहीं था जो हमें लोकपाल बनाना पड़ा. बहुत ही चिंटू क्वेश्चन है, इजी है, बताइए, एक एक करके बताइए. हाँ, ओके, ठीक है. सो व्हाई सीवीसी वाज, दिस इज एन इजी क्वेश्चन. व्हाई वाज सेंट्रल विजिलेंस कमीशन एक्ट 2003, व्हाई सीवीसी सेंट्रल विजिलेंस कमिश्नर एंड 2 विजिलेंस कमिश्नर्स, ये क्यों इनफ नहीं था जो इतना हंगामा हुआ? वी नीड अ लोकपाल. क्यों? व्हाई दिस कंसेप्ट? क्यों बताइए. सही, यू वर गिविंग द राइट आंसर. आई हर्ड समबडी वाज सेइंग ओके, सुओमोटो मोस्टली द केसेस. वेरी गुड पॉइंट कि सीवीसी को, जैसे आई अभी इन द आफ्टरनून आल्सो बिफोर 2 PM आई वाज सिटिंग विद एक सीनियर ही है, आईआरएसी है, तो वी वर टॉकिंग अबाउट दिस ओनली, कि इसी पे बात हो रही थी. सो द पॉइंट इज कि सीवीसी मोस्टली इन्वेस्टिगेट्स केसेस विच आर रेफर्ड बाय द सेंट्रल गवर्नमेंट. लेकिन ये तो चलिए एक बहुत अच्छा पॉइंट बोला है, कुछ इससे बढ़ के थोड़ा. सीवीसी हैज जुरिस्डिक्शन ओवर ग्रुप ABCD. CVC has jurisdiction over group A, B, C, D. There is no body in India where you can directly file a complaint from Prime Minister to Minister of State from Member of Parliament. It was CVC was not having jurisdiction over beyond that. The Lokpal is the first body in India where you can, although Prime Minister को लेके बहुत सारे norms है, no complaint can be filed against Prime Minister if it is a matter related to international relations, atomic energy, space, or matter related to external affairs or these matters. Getting my point? इस पे Prime Minister के खिलाफ complaint नहीं होगी. On other matters, अगर आपने Prime Minister के खिलाफ complaint की, if you have filed a complaint, एक secret sitting होगी पूरे entire लोकपाल की. 2/3 say if they will approve, then only they will proceed with the complaint against Prime Minister. You can file a complaint against Prime Minister, but there are certain safeguards. This is the first body where you can file a complaint against a sitting minister of the union or an ex-minister. यानी इसका jurisdiction wide. Second, you can file against complaint against members of parliament. For members of state legislature, you will file Lok Ayog. अब third point. अभी बात हो रही है कि concurrent jurisdiction हो गया. CVC is also having power over ABCD and Lokpal is also having power over ABCD. So sometimes there is a demand कि group ABCD को सिर्फ CVC के पास रहने दे and concentrate Lokpal on Council of Ministers and Members of Parliament. This is the first ombudsman where you can, और क्यों भाई? CVC you cannot file a direct complaint, although there is a provision Whistleblowers Act within the organization. In exceptional circumstances they can entertain a complaint. Here ombudsman की खूबसूरती, the beauty of ombudsman is anybody can file a complaint. You can file a complaint. अब बहुत, did I talk about Lokpal yesterday? No. अब सुनिए, सबसे पहला मैंने, मुझे लगता है आई टॉक्ड अबाउट, सबसे फर्स्ट थिंग, लोकपाल किसी को जेल नहीं भेजता है. लोकपाल डजेंट सेंड एनीवन जेल. दिस इज वन ऑफ द मिस. आप ही बताइए, लोकपाल में रिटायर्ड जजेस ऑफ सुप्रीम कोर्ट, एनीबडी कैन सेंड टू जेल आफ्टर एग्जॉस्टिव ट्रायल. तो ट्रायल कौन करेंगे? जुडिशियल मैजिस्ट्रेट फर्स्ट क्लास सेशंस जज ट्रायल करेंगे या जज सुप्रीम कोर्ट जज? जस्ट कॉमन सेंस लगाइए कि आई कैन शो यू द लॉ. आई विल ओपन द लॉ. यूजुअली इन द लास्ट क्लास वी हैव कॉन्स्टिट्यूशनल एंड स्टैट्यूटरी बॉडीज. आई डू दिस बाय द लॉ, क्योंकि एक सेकंड में लॉ वी कैन ओपन. सो कुछ बेसिक कंफ्यूजन जो आपको है वो मैं दूर कर दूं. पहला, लोकपाल इज द फर्स्ट बॉडी वेयर पीपल कैन फाइल अ डायरेक्ट कंप्लेंट. It is the first body which has jurisdiction over ministers as well as the members of parliament. Third, Lokpal doesn't send anyone jail. Lokpal किसी को convict नहीं करता है. What is the procedure? There are 3 wings in Lokpal. Director of Inquiry, you can download the law and you will read. Director of Inquiry, Director of Prosecution and Secretary to Lokpal. 3 विंग्स होते हैं, डायरेक्टर ऑफ इंक्वायरी, डायरेक्टर ऑफ प्रोसिक्यूशन एंड सेक्रेटरी टू लोकपाल. फॉर एग्जांपल, आई एम द लोकपाल एंड द बेंच कंप्राइजेस ऑफ 3 मोर मेंबर्स. हम लोग हैं. इन्होंने कंप्लेन की, इन्होंने इनके खिलाफ कंप्लेन की कि आई थिंक दैट ही इज इन्वॉल्व्ड इन करप्शन. So what I will do, I have two options. Either I will ask the any body established under Delhi Special Police Establishment Act, मैं वो दे दूंगा CVC को या सेंट्रल ब्यूरो ऑफ इन्वेस्टिगेशन और सेंट्रल विजिलेंस कमीशन एक्ट CVC को. They will conduct an inquiry and this is written in the law. They will give to me. Okay, they will give to me. Now I have two options. Prima facie, if I feel क्या इसमें कोई दम नहीं है, so I will ask for the closure of the complaint. Or I will ask for more investigation on a particular matter. More investigation will be done. Or I will say कि okay, this person has committed a small mistake. I will recommend the government कि इसको थोड़ा सा एक increment, promotion नहीं, एक increment रोक दीजिए, one increment. So I will say. Now the second time investigation will be done by Central Bureau of Investigation. अब आ गया मेरे पास. Now I will call director of what you call prosecution. मैं director of prosecution को कहूँगा कि जो हमारा कोर्ट है under लोकपाल एंड लोकायुक्त एक्ट special courts are established. Special courts are established. Get that person prosecuted in the special court. वहां पूरा सेशन चलेगा, पूरा ट्रायल चलेगा. यू विल बी गिवन एन अपॉर्चुनिटी. सो लोकपाल विल नॉट सेंड पीपल टू, हाँ उनको कुछ पावर है जैसे कॉन्फिस्केशन ऑफ एसेट्स करके, पर कन्विक्शन विल नॉट बी डन बाय द लोकपाल. लोकपाल विल डायरेक्ट द डायरेक्टर ऑफ प्रोसिक्यूशन कि भैया मेरे पास प्राइमा फेसी एनफ एविडेंस है. उसके अंदर व्हेन यू विल डाउनलोड द लोकपाल एंड लोकायुक्त एक्ट 2013, लास्ट में आई थिंक सेक्शन 35 समथिंग, यू विल सी कॉन्स्टिट्यूशन ऑफ स्पेशल कोर्ट्स. सो द सेंट्रल गवर्नमेंट विल कॉन्स्टिट्यूट स्पेशल कोर्ट्स अंडर द एक्ट एज रिक्वेस्टेड बाय द लोकपाल. जैसे यू हैव नार्कोटिक्स एंड साइकोट्रॉपिक सब्सटेंसेज एक्ट, उसके अपने कोर्ट्स हैं. जैसे प्रिवेंशन ऑफ करप्शन एक्ट, उसके अपने कोर्ट्स हैं. जैसे प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट, उसके अपने कोर्ट्स हैं. बहुत सारे लॉज हैं इंडिया में, उसको डील करने के लिए देयर आर स्पेशल कोर्ट. उसी तरह फॉर लोकपाल एंड लोकायुक्त, लोकायुक्त इज स्टेट, लोकपाल you have a what is lokayukt? The same thing that is for the state. So why every state government and legislature has passed lokayukt? So why they have mentioned over there, many states were reluctant कि हम lokayukt नहीं बनाएंगे. So article 253 of the constitution says in order to implement an international treaty or agreement, parliament can make a law even on state list. This question has been asked many times. Article 253 empowers the parliament to make a law on state list even if it falls within the domain of the state. Okay, अब इसमें वहां शुरू में ही लोकपाल एंड लोकायुक्त एक्ट आप डाउनलोड कीजिएगा, शुरू में ही लिख दिया है. Whereas India is a signatory to UN Convention Against Corruption. So giving a clear message to the states that this law is enacted to implement an international treaty or agreement. So Lokpal mein you have director of prosecution, director of prosecution, director of inquiry and secretary to Lokpal. भाई लोकपाल बूढ़े लोग हैं, सीनियर पीपल आर देयर. किसी भी इंसान को जेल भेजने के लिए यू विल हैव प्रॉपर ट्रायल विल बी डन बाय द Sessions Court, although if the offense is less than the judicial magistrate second class, judicial magistrate first class, 7 years and above, then trial will be done by a senior judge. So ये courts are established under, बहुत से ऐसे laws है where there are specific courts. Now let's see, Lokpal ने has established an inquiry wing under section 11 and Lokayukt Act. So Genesis Anti-Corruption Ombudsman first and second ARC ने रिकमेंड किया था, लोकायुक्त एट द स्टेट लेवल. अभी ये सब एकदम बेसिक फैक्ट है कि क्या है 8 में अब लोकपाल. आपको मालूम है मिनिमम एज टू बिकम लोकपाल. अब ये एक्ट तो आपको अब वी हैव टाइम, आई हैव चेक्ड कि ये सब टुडे वी विल कंप्लीट. वही बात है ना. Now if you see, I'll just within 5 minutes will scroll down the law. Okay, so if you see लोकपाल एंड लोकायुक्त एक्ट कुछ भी नहीं है. पहले ही बोल दिया कि स्टेट्स को ज्यादा शक्तिमान नहीं बनना है. वेयर इंडिया हैज रैटिफाइड यूएन कन्वेंशन अगेंस्ट करप्शन. ओके, सो इंटरनेशनल लॉ को इंप्लीमेंट करने के लिए अब शुरुआत होती है. लेट्स सी क्या भाई इससे क्वेश्चन आने के चांस है. व्हाट इज अ लोकपाल का कॉम्पोजिशन क्या है? टू इन ऑर्डर टू बिकम लोकपाल यू हैव टू बी अ चेयरपर्सन के लिए चीफ जस्टिस ऑफ इंडिया या ऐसा आदमी जो 25 इयर्स से इम्पीकेबल. आई सेड यस्टरडे आई थिंक मिनिमम एज टू बिकम लोकपाल 45. तो या तो वो इंसान व्हाट यू कॉल चीफ जस्टिस ऑफ इंडिया हो या सुप्रीम कोर्ट जज से रहा हो, या ही इज एन eminent person as specified in clause B of subsection 3 and number 25 years of outstanding ability and integrity. अब यही सारी चीजें हैं. मिनिमम एज है 45 years और इसमें पर्सन वो खुद ही ना कन्विक्टेड हुआ हो. गेटिंग माय पॉइंट? सो और सिटिंग मेंबर ऑफ पार्लियामेंट या कोई इसमें लोकपाल नहीं बनाए जा सकते। और सच आगे बढ़े, कमिटी कंसिस्टिंग ऑफ, अब यहीं पे यूपीएससी ट्रैप कर लेगी, सिलेक्शन कमिटी एंड सर्च कमिटी। अब भाई प्राइम मिनिस्टर, यू हैव लीडर ऑफ ऑपोजिशन एंड चीफ जस्टिस ऑफ इंडिया और अ जज नॉमिनेटेड। अब गौर से, यहां 3 ट्रैप है प्रीलिम्स का। फर्स्ट प्रीलिम्स ट्रैप, डिफरेंस बिटवीन सिलेक्शन कमिटी एंड सर्च कमिटी। प्राइम मिनिस्टर, चीफ जस्टिस ऑफ इंडिया जब बैठेंगे, अच्छा अच्छा किसका नाम लाए, ऐसा तो नहीं होगा। फर्स्ट दे विल बी अ सर्च कमिटी, उसमें सिविल सर्वेंट होंगे, वो प्रोबेबल नेम चूज करेंगे। तो सर्च कमेटी का काम है सिलेक्शन कमेटी को थोड़ा मदद, प्याज वाज काट के, मतलब दे विल चॉप द अनियंस एंड डू एवरीथिंग। नाउ इट द सिलेक्शन कमेटी विल कम एंड कुक द फूड। सो सर्च कमेटी विल choose the names, but it is written in the act that selection committee can choose a name beyond what is recommended by the search committee. अब legislature अपना power तो कभी, getting my point? So the point is now chief, अब ये है eminent jurist, गौर से सुनिए। सबसे पहले चीफ जस्टिस ऑफ इंडिया, प्राइम मिनिस्टर, लीडर ऑफ ऑपोजिशन एंड स्पीकर। वाई स्पीकर? क्यों यहां स्पीकर? वाई? बिकॉज लोकपाल ऑल्सो हैज पावर्स ओवर मेंबर्स ऑफ पार्लियामेंट, सो इसीलिए उन्होंने खास के स्पीकर को बहुत से, सेंट्रल इंफॉर्मेशन कमीशन एक्ट में भी है। नाउ कमिंग, नाउ द इंपॉर्टेंट थिंग रिलेटेड टू दिस इज कि पहले 4 लोग मिलेंगे और 5वां आदमी चुनेंगे। फर्स्ट ऑल द 4 विल मीट एंड दे विल चूज द 5th person, then the collegium will get completed. So and one eminent jurist as recommended by the chairperson and members in A to D. So पहले चीफ जस्टिस ऑफ इंडिया, प्राइम मिनिस्टर, व्हाट यू कॉल लीडर ऑफ ऑपोजिशन एंड स्पीकर, ये 4 मिलके 5वें को चुनेंगे, तब ये पूरी कोलेजियम कंप्लीट होगी। उसके बाद सिलेक्शन कमिटी शैल फॉर द पर्पस ऑफ सेलेक्टिंग द चेयरपर्सन प्रिपेयर अ पैनल ऑफ पर्संस और कॉन्स्टिट्यूट अ सर्च कमिटी। सर्च कमिटी कंसिस्टिंग ऑफ, इसमें सिविल सर्वेंट्स हैं बेसिकली और बहुत फाइनेंस वगैरह के नॉलेजेबल पीपल, पॉलिसी मेकिंग के। दीज पीपल विल, सर्च कमिटी का काम है कुछ नाम को छांट कर selection committee, so search name and provide not less than 50% members of such committee, minorities, women and all. Selection committee may also, हाँ ये लिख दिया है, provided that selection committee may also consider any other person other than recommended by the search committee. अब इसमें वही सारी चीजें हैं, कैसे इनको रिमूव किया जाएगा वगैरह। हाँ ये चीज बहुत अच्छी है कि कोई भी, दिस इज द ओनली लॉ, कंप्लीट बैन है कि सर्च, लोकपाल और लोकायुक्त से हटने के बाद 5 साल तक आप कोई भी इलेक्शन नहीं, मुखिया से लेकर प्रेसिडेंट तक। ओके, सो ऑन सीजिंग टू होल्ड ऑफिस, चेयरपर्सन एंड एवरी मेंबर शैल बी इनएलिजिबल फॉर रीच चेयर पर एनी डिप्लोमेटिक असाइनमेंट, फर्दर एम्प्लॉयमेंट, कॉन्टेस्टिंग एनी इलेक्शन फ्रॉम प्रेसिडेंट, वाइस प्रेसिडेंट फॉर 5। सो एकदम कंप्लीट कूलिंग ऑफ पीरियड है, हटने के 5 साल तक आप इंडिया का कोई भी इलेक्शन नहीं ले, यू कैन नॉट कॉन्टेस्ट द इलेक्शन, पार्लियामेंट हो, प्रेसिडेंट, ताकि आप फेवर ना करें किसी को। Okay, then you have inquiry wing, then you have prosecution, everything is written, कैसे आएगा उनके पास। अच्छा, प्राइम मिनिस्टर के खिलाफ अगर इंटरनेशनल रिलेशंस, पब्लिक ऑर्डर, एटॉमिक एनर्जी और स्पेस में कंप्लेन होती है, यू कैन नॉट फाइल अ कंप्लेन बिकॉज दीज इंफॉर्मेशन कैन नॉट बी रिलीज टू पब्लिक। अदर मैटर्स में कंप्लेन होगी तो एटलीस्ट 2/3 ऑफ मेंबर्स अप्रूव such inquiry, then any person who is or has been, matlab sitting or retired minister of the union, all such things are there. Now go back, you can read, we'll take a break also, just this. Okay, so for Justice Pinaki Chand, PC Ghosh was appointed as first Lokpal and Khanvilkar sir is current Lokpal. Okay, chairperson will be appointed after recommendation, all such thing, member will be eligible, Lok Sabha. Details क्या, अब ये देखिए, inquiry conducts a preliminary inquiry under prevention of corruption act within, headed by director of inquiry and director will be assisted by, think they can also send to, उसके बाद director of prosecution, power superintendent issued direction, powers service as a final appellate authority, public grievances कोई हो जाए, prime minister and all such things under the law. If you will see, एक चीज बस मैं दिखा दूं, और 2 things in fact last में you will find interesting. प्रॉपर्टी वगैरह अटैच कर सकते हैं लोकपाल। ओके, सो ग्रांट्स बाय द सेंट्रल गवर्नमेंट, डिक्लेरेशन ऑफ एसेट्स एंड ऑल सच थिंग। ओके, सो एक तो चलिए लोकपाल एंड लोकायुक्त एक्ट ने अमेंड किया था दिल्ली स्पेशल पुलिस एस्टैब्लिशमेंट एक्ट के, एंड द डायरेक्टर ऑफ सीबीआई विल बी अपॉइंटेड ऑन दिस रिकमेंडेशन, सो दे हैव added, they one act amended the other, just one more section, then we'll go back. फॉल्स कंप्लेन का प्रोविजन है, ये प्रीलिम्स में पूछ सकता है, जिसने किसी को फंसाने के लिए कुछ किया उसके बाद उस पर प्रोसिक्यूशन होगा. So false complaint, there is a provision, okay, related to false complaint, but only that person can file a complaint against whom the complaint was made. कोई और जनहित में, what you call, he will not go, and many people see, the central government shall constitute such number of special courts as recommended by the Lokpal to hear and decide the cases arising out of Prevention of Corruption Act under what you call 1988 or under the act. So this is National Commission for Backward Class, कुछ भी नहीं है. 100 National Commission for Backward Classes Act था 1993 का. 2004, don't write this, but 2014 बीजेपी मैनिफेस्टो में था that if we come to power we will give constitutional status to National Commission for बैकवर्ड क्लासेस. तो बीजेपी ने 2018 में द पार्लियामेंट ऑफ इंडियन रिपब्लिक, द गवर्नमेंट इंट्रोड्यूस अ बिल 102nd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, नेशनल कमीशन फॉर बैकवर्ड क्लासेस वाज गिवन अ कॉन्स्टिट्यूशनल स्टेटस. वही जो एससी लिस्ट है, एसटी लिस्ट है एंड OBC list, they have all the powers, duties, investigate, safeguards and inquire into socio-economic development and all. Article 338B, policy matters affecting the rights of chairperson, vice chairperson and 3 other members. These two will do 338 for a term of 3 years. In same hai, National Commission for, sorry. This we can do after the break. We come back, then we'll do. Okay. 5 minutes we can take. We come back, then we'll complete this. इसमें कुछ है नहीं है. related to all constitutional bodies. Hardly there are 7-8 articles. Okay, so before going for exam, you just go through those articles in verbatim. No need to memorize, but go through them originally as they are provided. Some kuch basic points सबसे related. First, what is the function? So they have functions to safeguard the particular community. Second, they are also consulted to include a particular community in SC, ST or OBC list, the respective commission. Third important thing, government also consults them for policies related to the particular thing. Usually when you will go to National Commission for Scheduled Caste or National Human Rights Commission, you will see कोई ना कोई बचपन से I have seen childhood से कि भाई कोई DMSP को NHRC ने बुला लिया. National Commission for Scheduled Caste called a DMSP. They have powers of a civil court. 2 years back also a friend came, he stayed at my flat only, so he went to one of these commissions, what you call, so the point is बहुत common है कि इस district magistrate या superintendent of police को they call, if there is an atrocity in their district, they have investigative powers, they can summon them, all such things, but ultimately they have powers which are advisory in nature. अब जैसे कि ये यूपीएससी, यू नो आर्टिकल 315 ऑफ द कॉन्स्टिट्यूशन, यूपीएससी ज्वाइंट पब्लिक सर्विस कमीशन इज अ स्टैट्यूटरी body. कल कोई somebody came, so joint public service commission is a statutory body, ineligible for further employment. ये बहुत बहुत basic facts हैं. Ineligible for further employment लेकिन can be appointed as a governor. yes और no से मैं मानूंगा. yes क्यों? तो yes और no ही आंसर होगा. yes no नहीं होगा, या तो yes होगा या तो no होगा. It is not an this is the correct answer. It is not an employment under the government. KK Paul sir the, he was Delhi Police Commissioner. Later on he was appointed as member of UPSC. Then he was appointed as governor. So office of governor is not a employment under government of India, but a constitutional. So he is eligible to be appointed. State Finance Commission, you know, state finance. बस दो अंतर है. पहला, in Article 280 it is written the principles which should govern granting aid, allocation of funds between center and state and among the state. 243I same which all taxes will be given to the PRIs and municipality. बस एक अंतर है. In Article 243I heading में दिया है principles. So actually the State Finance Commission doesn't recommends the principles broadly on these parameters. What all taxes will be given to the municipalities. बहुत example, all of us pay municipal tax. जब आप you will pay municipal tax for your municipal corporation. Who has empowered the municipal corporation to impose that, levy that tax? State legislature. State legislature, of course, no tax shall be levied or collected save by the authority of law. Article 265 of the Constitution. State Finance Commission will recommend, जैसे दिल्ली में आप कैब से इंटर कीजिएगा, कहीं से भी आ रहे हैं, if you are entering in a cab, even if it has a Delhi number, you have to pay. पहले 100 rupees था, अब शायद they have increased it to 200. और देखिएगा MCD का स्टिकर लगाया होगा आगे. So 3000 rupees multiple entries zillion times in a month. Okay, 3000 rupees. Who has, so कहीं से भी, नोएडा से घुसिए, गुरुग्राम की तरफ से आइए, come from सरिता विहार साइड, कहीं से भी जाइएगा, जैसे ही you will cross बदरपुर, 200 rupees कैश में, अगर वो चिपकाए हुए हैं, that, so you'll pay 3000 rupees a month multiple. So कहीं से भी कोई cab और other commercial vehicles का cost ज़्यादा है. So why cabs pay, even if it has a Delhi registration, then also you have to pay 200. It was 100 rupees, now I have heard, I'm not sure it is increased to 2. Who asked? Who? Because the municipal authorities have been empowered to levy that. Also the State Finance Commission will recommend कि चलिए ये सब इनको, जैसे house tax you pay to the municipal. I have personally paid. So the for example the municipal corporation pays what you takes the money. Who empowers them to levy such tax? The state legislature. So all these things are recommended. Commission, net proceeds of taxes, duties and tolls which may be assigned to the मालूम है ना पंचायत. आर्टिकल 243 स्मॉल लेटर बी एंड आर्टिकल 243 कैपिटल लेटर बी. पंचायत मतलब बॉडी एट विलेज लेवल, इंटरमीडिएट लेवल एंड district level. Panchayat does not mean body at village level. It is defined in the constitution. 243B, the panchayat mean body at village level, intermediate level and district level. अब to जैसे Union Finance Commission will distribute between center and state, State Finance Commission will distribute between state and PRIs and different levels of the PRIs. What will go to the district and intermediate and what you call village level. Same है 243Y for municipality. Central Vigilance Commission statutory body है. 2003 में statutory recognition मिला. पहले just एक resolution पे था. Statutory status पहले ordinance pass हुआ फिर approve all such things. Just remember this, what is the function. Law Commission is an important thing. That 1st September 2024 से 31st August 3 year Law Commission has been constituted to recommend the legal reforms composition. It is, अगर मुझसे पूछिए, one of the oldest bodies is Law Commission, जिसमें continuity है. Public Account Committee 1921. Law Commission से old तो इंडिया में कोई body. There can be other bodies, that Asiatic Society or any such thing, but Law Commission is also very, very old. First constituted in 1834 by Governor General under Charter Act. Post independent इंडिया के बाद जो पहला लॉ कमीशन बना 1955 में, नॉन स्टैट्यूटरी बॉडी, नोटिफिकेशन, रिफॉर्म लॉज टू मैक्सिमाइज जस्टिस, कंडक्ट रिसर्च एंड रिकमेंडेशन. एक तरीके से जैसे गाड़ी को यू सेंड टू सर्विसिंग, लॉज आर सेंड टू सर्विसिंग टू द लॉ कमीशन. इट इज अ नॉन एक्स्ट्रा कॉन्स्टिट्यूशनल नॉन स्टैट्यूटरी बॉडी. इसके लिए नीति आयोग के लिए 1 जनवरी 2015 को नीति आयोग में क्या क्या क्वेश्चन आ सकते हैं. नीति आयोग वेबसाइट इज अ पोटेंशियल what you call very important hotbed of questions. Okay, so Niti Aayog में you go to the website of Niti Aayog. Okay, सबसे पहले तो नीति आयोग you should know indices. Okay, so list of indices which are released by Niti आयोग. एक क्वेश्चन मेंस में डायरेक्ट आया था, कोऑपरेटिव फेडरलिज्म, यहीं से उठा के सीधा कॉम्पिटिटिव फेडरलिज्म एंड कोऑपरेटिव मेंस में. बट प्रीलिम्स में दीज आर द इंडिसेस दैट आर रिलीज बाय द नीति आयोग. तो पता होना चाहिए विच ऑल इंडिसेस आर रिलीज बाय नीति आयोग, व्हाट आर द कंपोनेंट्स ऑफ दैट इंडिसेस. ओके, विच ऑल इंडिसेस आर रिलीज, प्रीलिम्स का क्वेश्चन है. विच ऑल फॉलोइंग इंडेक्सेस आर रिलीज बाय द नीति आयोग. अगर मेंस के लिए फर्स्ट कैबिनेट रेजोल्यूशन ऑफ नीति आयोग इज वेरी वेरी इंपॉर्टेंट, विच इज ऑलवेज डन. Although means I will not say, but yes, just take 30 seconds. Okay, this is the cabinet resolution on Niti Aayog. This you gazette 1st January 2015 को. Reasons behind constituting नीति आयोग बहुत अच्छा डॉक्यूमेंट है. It will give you an insight why the government of India constituted नीति आयोग. So you can download. पूरा रीजन दिया हुआ है एक एक करके. 12 पे दिया हुआ है कि समराइज करके एंट्री 12 पे कि वाई वी कॉन्स्टिट्यूटेड नीति आयोग, गांधी जी ने क्या कहा, स्पिरिट बिहाइंड नीति. सो मेंस इट इज वेरी इंपॉर्टेंट. सो प्रीमियर थिंक टैंक है, प्राइम मिनिस्टर है चेयरपर्सन, ये सब गवर्निंग काउंसिल में सीएम है, ऑल स्टेट्स के एक्स ऑफिशियो मेंबर्स हैं, रीजनल काउंसिल्स हैं. इट इज द थिंक टैंक, इट इज द थिंक टैंक. टीम इंडिया विंग है इनसाइड द नीति आयोग. इट इज द थिंक टैंक. ओके, सो ट्विन मैंडेट, मॉनिटरिंग द सस्टेनेबल डेवलपमेंट गोल एंड कॉम्पिटिटिव एंड cooperative federalism. It functions on bottom up approach. Think tank है, team india wing है, cooperative federalism. What is competitive federalism? हाँ, among the जैसे aspirational distinct, मतलब 5 भाई बहन है. father said whoever will score 90 plus I'll give watch. Okay, so the wrist watch. So the point is कि दे ऑल आर कॉम्पिटिंग बट दे आर नॉट एनिमी ऑफ ईच अदर. ये आई एम जस्ट लिफ्टिंग फ्रॉम द वेबसाइट ऑफ नीति आयोग. सो इन अ हेल्दी मैनर एक दूसरे से कॉम्पीट करना, एक दूसरे को हैंड होल्डिंग अप्रोच के साथ. सो दैट इज कॉम्पिटिटिव फेडरलिज्म. ओके, सो दिस यूनिवर्सल पोस्टल यूनियन, दिस इज एन ओल्ड कंसेप्ट. जनरल पोस्टल यूनियन ऑन दिस डे ट्रीटी ऑफ बर्न से बना, वर्ल्ड पोस्ट डे. ओके, हेडक्वार्टर्स बर्न एंड ऑल दिस इज अ नेशन स्पेशलाइज्ड एजेंसी. 150th एनिवर्सरी वाज constituted. नीति आयोग की रिपोर्ट released all such thing. You must know basic idea about these reports. CEO is appointed and he's having the rank of a secretary of to the government of India. यहाँ UPSC कभी कभी पूछ देती है has a rank of a cabinet minister and all those things you must remember. ये तो मालूम होना चाहिए. Experts nominated and GST council का कौन है. Right to information. You know we are 20th anniversary. Right to information. Right to information. 30 days, within 30 days. अब UPSC add कर देगा within 30 working days. लॉ में इट इज विद इन 30 days. Any information related to life and personal liberty has to be given within 24 to 48 hours. Otherwise, the information will be given within 30 days. 20th anniversary we are celebrating came into force. Access to information, DOPT, Universal Declaration of Human Rights, और as a human right in Freedom of Information Act को किया था. उसके बाद later this law was. राज नारायण केस में सुप्रीम कोर्ट ने कहा, क्यों कहा? What, see, there is no speech and expression without information. क्यों? Whatever I said in last 4 days, okay, I have said what I have read somewhere else. If I said tomorrow you have to present a paper on GM crops, okay, but nobody is allowed to look into any book or any internet. कल आप GM पे एक लेक्चर देंगे जेनेटिकली मॉडिफाइड क्रॉप्स पे, कोई भी बुक या कोई भी इंटरनेट नहीं देख सकता है. देन यू विल नॉट बी एबल टू स्पीक हार्डली. वाई? बिकॉज मेरी पूरी फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन डिपेंड करती है कि मुझे कितना इंफॉर्मेशन available, to what extent I have information that I can speak. So freedom of information is necessary for speech and expression, and of course inclusive democracy, transparency, accountability, inclusive governance, वो सारी बातें हैं. पर मैं बोल ही नहीं सकता हूँ बिना information. I cannot speak without having information. Our teacher said you have a fundamental right to speech, and you also have a fundamental right to speak what others have spoken. So the information free flow नहीं करेगी. Our freedom of speech and expression is incomplete without accessing information. Whatever I said in all these days, it's not invented or what discovered by me. I have said what I have read. So what my ability to access information is directly proportional to my ability to express myself. So इसीलिए freedom of speech and expression is incomplete without accessing. And for you want to speak, criticize the government or praise the government, for that also you need information. So Central Information Commission, central level पे State Information Commission appointed by a committee. This is very easy. Prime Minister, leader of opposition है. For example, you will file a RTI in a central government ministry. You are not satisfied, you will go to an appellate authority within the ministry. Then you will go to Central Information Commission. Principal bench is in New Delhi and other benches. If you are not satisfied, you will go to High Court. If you are not satisfied, then you will go to Supreme Court. सबसे important judgment है 1, 3rd June 2013, bringing political parties under the purview of RTI Act. सिर्फ आप 3rd June 2013 जजमेंट कीजिएगा तो एसोसिएशन फॉर डेमोक्रेटिक रिफॉर्म्स का एक PDF पेज खुलेगा. दैट्स अ वंडर. व्हाई पॉलिटिकल पार्टी शुड बी ब्रॉट विद इन द परव्यू ऑफ RTI एक्ट. 10 years से ज्यादा हो गए. द सेंट्रल इंफॉर्मेशन कमीशन रूल्ड दैट पॉलिटिकल पार्टीज डू कॉन्स्टिट्यूट एज पब्लिक अथॉरिटी अंडर सेक्शन 2 स्मॉल लेटर h ऑफ द RTI एक्ट 2005. मालूम है ना, सेक्शन 2H ऑफ द RTI एक्ट 2005 कहता है पब्लिक अथॉरिटी. सो दे से पॉलिटिकल पार्टीज आर आल्सो पब्लिक अथॉरिटीज अंडर सेक्शन 2H ऑफ द RTI एक्ट 2005. सो ये जजमेंट आ गया, पर पार्टीज इसको सेक्शन 2H तो आपको मालूम नहीं है, तो फिर इसका मतलब आप सिर्फ RTI व्हाट्सएप यूनिवर्सिटी से पढ़े. ओके जैसे आर्टिकल 12 स्टेट का डेफिनेशन, नहीं नहीं ये सीरियस बात है. आर्टिकल 12 इज द डेफिनेशन ऑफ स्टेट. आर्टिकल 36 इज द डेफिनेशन ऑफ स्टेट फॉर DP SP. कौन कौन RTI एक्ट के अंतर आता है? हु ऑल कम अंडर RTI एक्ट इज गिवन इन सेक्शन 2 स्मॉल लेटर h ऑफ द RTI एक्ट. सेक्शन 2 स्मॉल लेटर h ऑफ द, अब इसी की लड़ाई है. वहां लिखा है NGO, अदर अथॉरिटी. सो इसमें वो इंटरप्रिटेशन होता है वेदर दिस अथॉरिटी इज ऑल्सो पब्लिक. नोबडी वांट्स टू बी कॉल्ड एज public authority. So political parties, अब गौर से सुनिए, nobody wants to be called as state, because if BCCI is not a state, Supreme Court ruled, if BCCI will be declared as state, then fundamental rights will be applicable against BCCI. So nobody wants to be declared as public authority. If they are declared as public authority under section 2H, then RTI will be filed in their office also. So Supreme Court ने ये Central Information Commission ने 3rd June 2013 को judgment दिया that political parties also come under the definition of public authority under section 2H of the RTI Act, and because they did उसके लंबा reason दिया, you'll find they derive tax benefits, they derive rent free accommodation, इतने फायदे हैं. So पर कोई other than few parties have not implemented. This matter is pending in the Supreme Court. ये एक judgment है. दूसरा Central Public Information Officer CPIO Supreme Court of India versus Subhash Chandra Agarwal. That is whether the office of CJI comes within the purview of RTI Act or not. ऐसे भी you can search RTI CJI SC Observer. You can read on the website otherwise. So ये RTI यानी अगर आपको information सही नहीं मिल रही है, not giving, then you can go to the CIC, or that is not very accurate, or you feel more information, you will go to the CIC. Okay, state government office है, so State Information Commission. Every citizen has a right to information from public authority. They will maintain the records. Public authority includes authorities, institutions established by law or substantially, अब यहाँ लिखा है substantially financed. So अब इसमें Madras High Court ruled that cooperative societies registered under are not public authorities. Supreme Court ruled that, अच्छा यही है, ruled that office of CJI is a public authority. Subhash Chandra Agarwal versus Central Public Information Officer, Supreme Court of India versus SC Agarwal. This is section 8 news में रहता है, which all authorities are exempt from providing information, intelligence and all 27 organizations. Okay, so lower courts writ jurisdiction High Court और Supreme Court में आती है. Penalties within 30 days और life liberty within 48 hours, all such things are there. RTI में amendment हुआ था, ये तो सुने ही होंगे, this was कि central government will decide the tenure and all those things, which was taken from the legal statutory perspective. Now central government will prescribe the terms and salaries and all such things. Okay, so this is something which is there. समझ रहे हैं? यानी just wrapping up, right to information is a part of speech and expression. The law was passed 2019 में law को curtail किया गया. Many things which were given in the law, now the same thing will be decided by central government. If you are aggrieved by an office of central government, then you will go to CIC or regional benches. If you are aggrieved by an office of state government, you will go to State Information Commission. दोनों के खिलाफ अपील लाई करेगी, against both of them will lie in the High Court. Famous judgment मैंने दो बता दी, ये कैन मेंस में भी पूछ सकता है, पॉलिटिकल पार्टीज अंडर आरटीए. सुप्रीम कोर्ट ने कहा आधार कैन बी यूज्ड एज आइडेंटिटी, इट इज नॉट एन अथॉरिटेटिव प्रूफ ऑफ डेट ऑफ बर्थ, इट इज अ 12 डिजिट नंबर. अब यूपीएससी का फेवरेट आइडिया है 12 डिजिट अल्फा न्यूमेरिक नंबर, यूनिक आइडेंटिफिकेशन अथॉरिटी, रैंडम. Also Aadhaar is not a proof of citizenship. ये तो of course electronic benefit transfer, all such thing. Yet Aadhaar metadata cannot be stored for more than 6 months, does not violate fundamental right to privacy, opening bank account, all such things. And this is a unique identification is a statutory body functions. अब इसका सब कुछ समझ लेते हैं. With respect to Aadhaar, the what you call Aadhaar project was initially started. The reason is very simple. Every country has the database of the residents in the country. It is not a citizenship document. So a retired judge of Karnataka High Court, K.S. Putta Swamiji, filed a petition in Supreme Court. Meanwhile, the Parliament passed the law Aadhaar Act taki to give a statutory recognition to Unique Identification Authority of India. Supreme Court ne kaha, nahi, it is not a violation of fundamental. Although right to privacy is a part of Article 21, but Aadhaar is a constitutional law. Reason simple है, एक second में समझ जाएगा. In every house you have, for example, 4 gas connection. Common है India में. 1 or 2 gas connection, because if you have, you will file your what you call number for the next gas. So he will bring after 15 days, and so you need at least 2 gas connections. Usually you have 3 to 4 gas connections. Now Aadhaar gas connections were not linked with Aadhaar. So government was giving subsidy on 4. Now they have asked ki bhaiya link your gas connection with Aadhaar. So you can have only 1 gas connection, 3 gas connection. The government you can run, but you will pay the market price. You will pay the market price. You will not get subsidy. For example, a person has 2 PAN card, Rakesh Kumar and for example Rakesh KR. Okay. So if he has 2 PAN cards, so he will link one with other bank, one with other bank. Now 2.5 lakh इसमें भी exemption लेगा, 2.5 lakh इसमें भी लेगा. Now because you know that is exempt. So now you have to link with Aadhaar. You can have only 1 PAN. So because of Aadhaar, crores of rupees are being saved as subsidies. Section 57 of the Aadhaar Act was declared as unconstitutional, which empowered the what you call the this thing private companies to gather Aadhaar data. Private companies force नहीं कर सकती, although government is contemplating to bring a law. Otherwise Aadhaar के लिए आपको force, private companies cannot force. I went to buy a SIM. He said कि without Aadhaar you will not get. हम बोले So I went to next shop and I got with the driving license, because I know he cannot force me. It usually doesn't happen, but I lost that SIM. So I again went for the SIM. This time अब तो Aadhaar. Again I gave what you call the not Aadhaar. But when I was taking Wi-Fi, he said कि sir Aadhaar लगे. हम बोले अच्छा चलो virtual ID ले लो. Getting my point? So you know virtual. All of you know. Some of you, if you don't know, you can generate a virtual ID that is linked to your Aadhaar. Zara, if you every time you go download Aadhaar app, download virtual ID. Ab you will print it. Your virtual ID will be printed, but Aadhaar will not be printed. Virtual ID is linked with Aadhaar. Virtual ID, for example, you felt that somebody saw your virtual ID. एक click कीजिएगा, virtual ID will change. So then I gave him virtual ID for Wi-Fi. He said कि sir ये तो आधार ही नहीं है. हम बोले अब ये डालिए तो आप भाई. Then he put that number. Immediately it got what you call to, because it is actually you can give Aadhaar or virtual, and OTP came and he verified the same. So you can generate a virtual ID. Don't give Aadhaar, but give, even if Aadhaar is required to be given, then give your virtual ID that is linked to आधार. और आधार ऐप पे जाके सबसे पहले बायोमेट्रिक को लॉक कीजिए और आधार वेरिफिकेशन को लॉक कीजिए. कोई यूज नहीं कर सकता है. इवन इफ यू वांट यू कैन ओपन इट फॉर, हाँ, बट वन थिंग इज देयर, वर्चुअल आईडी जनरेटेड एंड आधार लॉग्ड, दे कैन, यू कैन ओपन ओनली विथ what you call virtual ID. So virtual ID का benefit ये है, you can use it and it is use and throw. You can use it, मतलब throw नहीं, मतलब you will use it, but the beauty of it is you can change it any time और आपको आधार देने की जरूरत नहीं है. और सेक्शन 57 को लेके लड़ाई थी कि भाई प्राइवेट कंपनीज आर टेकिंग, सो द सुप्रीम कोर्ट गिव अ वेरी प्रोग्रेसिव थिंग. आधार इज एक्चुअली अ वंडरफुल थिंग बिकॉज इट हैज सेव्ड द कंट्री अ लॉट ऑफ मनी. ठीक है, देयर इज अ प्राइवेसी एंड ऑल दोस थिंग्स आर देयर, बट एट द सेम टाइम दिस इज गुड फॉर द कंट्री, क्योंकि भाई सब्सिडीज बच रही है. एंड यू मस्ट नॉट यूज, मैं देखता हूँ ऐसे ही आधार समोसे की तरह, आधार नहीं, ऐसा नहीं. आधार इज अ वेरी, आई रिमेंबर इन लाइफ हाउ मेनी टाइम्स आई हैव यूज्ड आधार. I remember hardly 5 or 6. Otherwise, either I tried not to give driving license or something, or I give virtual ID, which if leaked, you can immediately change it. Okay. So Aadhaar is a wonderful thing, but use it responsibly. Centrally sponsored scheme, you know that centrally sponsored scheme is based on subgroup of chief ministers. 75 centrally sponsored scheme in 3 categories. All transfers are through Consolidated Fund of India. आपको मालूम है कि 14 फाइनेंस कमीशन ने जब नॉन प्लान एक्सपेंडिचर ये सब कर्व किया था. सो दिस इज फंडिंग पैटर्न इज 90-10 फॉर नॉर्थ ईस्टर्न स्टेट. अदर स्टेट इट इज 60-40 एंड यूनियन टेरिटरीज विदाउट लेजिस्लेचर इट इज 100. दिस इज ऑल्सो वन ऑफ द रीजन वाई that what you call union territories without legislature, because union territories without legislature को ठीक है, थोड़ी सी autonomy कम है, लेकिन फायदा अनेक, because 100% finance is given by the center. All such things are there. हो गया क्या? Types of central core, इसमें है core schemes, core of the core schemes and optional scheme. This is very important. Mission Karm Yogi, National Capacity Building Program for Civil Servants. नेशनल कैपेसिटी बिल्डिंग प्रोग्राम फॉर सिविल सर्वेंट्स. मिशन कर्म योगी, जिसमें यूपीएससी में भी जो मैं विजिबल ट्रांसफॉर्मेशन देख रहा हूं, यू आर टेकन टू द स्टैच्यू ऑफ यूनिटी वेयर देयर इज अ पिक्चर विद द प्राइम मिनिस्टर. सेकेंड 2015 बैच से पहले, आफ्टर कंप्लीटिंग योर सेकेंड फेज, डायरेक्टली यू ज्वाइंड एज एसडीएम. अभी उन्होंने चेंज कर दिया कि नहीं, आफ्टर कंप्लीटिंग योर सेकेंड फेज यू विल बी इन दिल्ली फॉर I think 1 or 45 days or 2 months as a assistant secretary. I have Civil Services Institute है इंडिया गेट के पास, मैं कई बार गया था पहले, अभी तो नहीं. वहाँ all the probationary officers stay for 2 months or 1.5 months whatever as assistant secretary in various ministries. यानी पहली बार the IAS probationers used to come to the center after 8 years at joint secretary, but during the training now they are also posted in Delhi as assistant secretary, and there they are, so that they are exposed of the working of the center. और सिविल सर्विसेज इंस्टीट्यूट है वहीं पर, वहाँ पे 2-3-4 बिल्डिंग है, उसी में एक हॉस्टल, मतलब दे गिव टू द सिविल सर्वेंट 2-3 हॉस्टल्स. सो द पॉइंट इज, बहुत सारे ये सब पार्ट है नेशनल कैपेसिटी बिल्डिंग प्रोग्राम फॉर सिविल सर्वेंट. दिस इज ऑल पार्ट. मिशन कर्म योगी, यू हैव द असिस्टेंट सेक्रेटरी, बहुत सारा है. फॉर 1 day एग्जाम देयर विल बी नो इंटरव्यू, सेल्फ अटेस्टेड, नो नीड टू हैव अटेस्टेड फ्रॉम एन एफिडेविट गेजेटेड ऑफिसर. ऑल दीज आर changes in the civil service, reforms in the civil. IGOT platform है इसमें, where all the material will be there. अब जैसे state PSC का भी joint training होता है, इसका तो governance में I have taught a lot about this. joint, जैसे मध्य प्रदेश में देखे, JK में भी एक friend है DSP, और बिहार में भी है, दोनों पहुंचा हुआ है. So मतलब there is a joint training center for state PSC. उसी तरह फॉरेस्ट रेंजर इन महाराष्ट्र, ही इज बीइंग ट्रेन्ड इन दार्जिलिंग, सो दार्जिलिंग में देयर इज एन इंस्टीट्यूट फॉर ऑल द फॉरेस्ट. उसी तरह स्टेट पीएससी ऑफिसर्स गो टू हैदराबाद. सो अब कोशिश हो रही है कि पैन इंडिया तो ट्रेनिंग गोज ऑन, बट देयर शुड ऑल्सो बी कोलैबोरेशन अमंग द स्टेट, सो दैट देयर इज अ कोलैबोरेशन अमंग द स्टेट पीएससी ऑफिसर्स ऑल्सो, यूनिफॉर्म ट्रेनिंग स्टैंडर्ड. ये सब रिफॉर्म आया है, दैट इज मिशन कर्मयोग. सुप्रीम कैपेसिटी बिल्डिंग कमीशन बना है, आईजीओटी प्लेटफॉर्म बना है, उसके बाद कैपेसिटी बिल्डिंग प्रोग्राम है. इसका एक जबरदस्त पीडीएफ है, that if I get time I'll show you today only. National program for civil services capacity building. So इसमें क्या है, create professional well trained civil servants, इसमें ये सब है. ये सबसे ऊपर है प्राइम मिनिस्टर्स HR काउंसिल, उसके बाद कैबिनेट secretariat coordinating unit, then capacity building commission or special purpose vehicle that will implement the IGOT online platform learning skills. Bihar Public Service Commission civil servant will learn from Odisha, Odisha will learn from Maharashtra. All content will be uploaded on IGOT. Principles are shift from rule based to रोल बेस से मैंडेट है कि भाई लर्निंग एक्सपीरियंस भी होना चाहिए. एक सीलोज अप्रोच से ज़्यादा थोड़ा व्हाट यू कॉल स्पेशल टेलर मेड अप्रोच होना चाहिए. और आईजीओटी प्लेटफॉर्म ये कमीशन बना है, कॉन्स्टिट्यूटेड थ्रू गजेट ऑफ इंडिया, इंडिपेंडेंट बॉडी, 3 members have been appointed. Program preparation of capacity building program, annual state of civil services report, approving knowledge partners for the mission, all such thing. ये आपको just we have how much time? Okay, just 5 minutes. So you can search here National Capacity Building Program for Civil Servant PDF. So if there will be a PDF, okay, कुछ और ही खुल गया, लेकिन you can search and you will get. I will not waste time on that. So उसमें बहुत अच्छे से दिया हुआ है pillars of IGOT, all such thing. Now we have how much thing? If we have more, we will. Okay. No problem, 5-7 minutes will take. Don't worry, nobody will die, I know. Okay. So now the point is, I will also not die. 5 minutes, maybe. मतलब ऐसे तो आइए. So the point is, recently Ministry of Personal Public Grievance has issued comprehensive guidelines for handling public grievances. Nodal officer will be there, dedicated. These are important, not very important from, honestly speaking, prelims. But you just go through this. This is index they can ask. GRAI. GRAI is with respect. एक क्वेश्चन पूछा. Swayam, 5 years, 7 years back, they asked the question. Swayam app is related to what? The education sector, textile sector, ऐसे करके 4 दे दिया. So GRAI में they will not, is related to what? Grievance word use नहीं करें. Complaint formation. Getting my point? और उसमें लिखेगा related to textile, related to external affairs, knowledge building. वहाँ grievance नहीं. Then you should know. अच्छा, उस वक्त दिमाग will not work कि GRAI मतलब ग्रीवांस हो सकता है, ग्रीवांस मतलब कंप्लेन. सो इस तरह करके दे कैन आस्क. ओके, सो डेडिकेटेड सेल्स, ये सब बेसिक है, डिपार्टमेंट ऑफ पर्सनल एंड ऑन. ग्रीवांस इंपॉर्टेंट टू मेजर इफेक्टिवनेस. द ग्रीवांस रेड्रेसल मैकेनिज्म बेसिकली क्या है, दैट गाइडलाइन इशू किया है, नोडल ऑफिसर्स सेल्स होने चाहिए. ग्रीवांस रेड्रेसल इंडेक्स है टू सी हाउ मिनिस्ट्रीज आर सॉल्विंग द प्रॉब्लम, रैंकिंग देम and issued on monthly basis to measure the effectiveness. Nodal agencies इसमें ये 2 हैं. Online platform, ये तो CP grams तो आपने सुना ही होगा, very very famous CP gram. This is the online platform to form a complaint against any government department 24/7. This is actually a effective one. So all these constitutional bodies लिखा है प्रगति, proactive governance and timely implementation. CVC, Lok Ayog, National Human Rights Commission, State Human Rights Commission, Jan Yojana Abhiyan. Now these questions are pure prelim specific. See, National Capacity Building Program Civil Servant is a very important topic. You will find a PDF. Why UPSC has not asked that? Because they are asking in mains. But any day they can ask in prelims. और उसमें इतने pillars हैं, all many pillars कि आपका गलत होना तय है. If you तुक्के से solve, no, you will not solve that. So go through National Capacity Building Program for Civil Servants, Prime Minister's Human Resource Council, Capacity Building Commission, Cabinet Secretariat, Central Monitoring Unit, IGOT platform. What are the pillars of this? All such you will find on internet also. Here also it is given. Just Ministry of Panchayati Raj launched the People's Plan campaign, preparation of Panchayat Development Plan. Okay. टू पीपल्स पार्टिसिपेशन इंक्रीज करने के लिए, 3 टायर में इंप्लीमेंटेशन करने के लिए, वार्ड सभा में पीपल विल प्रिपेयर द प्लान, व्हाट शुड बी टेकन इन द दिस ईयर, थीमेटिक अप्रोच, ऑल सच थिंग्स आर देयर. ये तो पुराना मुद्दा है. The Constitution of India says that the accounts of the local bodies shall be audited in the manner as prescribed by the state legislature. Now, International Center for Audit, this I have taught in current affairs also, Center for Audit for Local Governance was inaugurated in Gujarat. Okay, set global standards for auditing local government. Constitutional provision है in the manner provided by state legislature. Collaborative ये जो body बनी है, they will provide as a platform for policy makers and auditors, independence of local government, knowledge think tank. Then they have given 73rd and 74th amendment. CAG, now this is something which is CAG's mandate for audit for local bodies, CAG's powers and duties act है, controls the supervision. Although एक और provision है कि CAG, there is a law that provides CAG for audit of local bodies. Okay, so this is something examiner of local funds account. There, in between, I think 1.5 years back or 2 years back, I was teaching that CAG is contemplating to open office in the district also to audit the account of local bodies, which it gets through other officers. इससे क्या होगा? There will be more vacancies for Indian audit and account services, getting my point. But anyways, so CAG exercises control and supervision over maintenance of accounts, but control and supervision, it is done through examiner of local fund account. All such things are there. So basic part, devil 243G, it is the oxygen of part 9. Article 243G, which I have said before also. J, maintenance of account. 243J, legislature of state may by law provide for the provision for the maintenance of accounts and auditing of such account. I said na, such power is given to the state legislature. Now they have cantonment board, you know. India में Cantonment Act 1924 amended in 2006. Some of you will join Indian Defence State Service. I have a very close friend. IDES. IDES में you will become the CEO of cantonment. हर cantonment में एक CEO होता है. Chairman of the cantonment is the ex officio commanding officer of the cantonment, who is the ex officio chairman. President होंगे जो commanding officer होंगे. CEO would be Indian Defence State Service. आपका काम है municipal services in cantonment एरिया. सो यू विल ज्वाइन. डिफेंस में भी कुछ सिविलियन ऑफिसर होते हैं, जैसे इंडियन डिफेंस स्टेट सर्विस, इंडियन डिफेंस अकाउंट सर्विस, एसएससी के थ्रू आर्म फोर्सेस, what you call services related to armed forces headquarters service. UPSC में armed forces headquarters service group B. So some civilians are also sent to defense. So one is this. So cantonment board है. इसमें land portions from 10 cantonment boards merged with the state local bodies. Cantonments are, what is a cantonment? Where military is stationed permanently. Where military is stationed permanently. So 5 बातें. पहला, Cantonment Board Act 2006. Second, President is the commanding officer of the cantonment, is the ex officio chairman. Third, CEO is Indian Defence State Service appointed by the President. 4, municipal administration in cantonment areas. 5th, there are members partially elected and partially nominated. 6th, the cantonment board जो है comes under Ministry of Defence. Ministry of Defence. What is a cantonment? A place where military is stationed permanently. All the facilities related to cantonment. अब इसमें अब कभी वो CEO is a good, कभी वो defense state officer भी बनते हैं related to defense land. Okay, all such thing. Comprises of military troops are garrisoned and primarily dedicated to housing soldiers, military and civilian population. Battle of Plassey. Cantonment Act 2006 आया in accordance with 74th Constitutional Amendment Act. Okay, it comes under the Ministry of Defence. में एक और चीज है, it has done away with the previous law, Cantonment Act 1924. Cantonment boards ex officio president is the commander of the station, and वो नहीं लिखा Indian Defence State Service से they will become. Constitutionalization of environment, very important. Supreme Court ने rule किया है right to healthy environment is not only covered under Article 21 but also under Article 14 of the Constitution. Right to be free from adverse effects of climate change should be recognized by 14 and 21. ये judgment है रंजीत सिंह versus यूनियन ऑफ इंडिया, आर्टिकल 14 एंड 21. वाइड द स्कोप इंक्रीज कर दिया. सो फंडामेंटल राइट्स का वेल्लोर सिटीजंस वेलफेयर फोरम केस, पोल्यूटर प्रेज प्रिंसिपल, एमसी मेहता, राइट टू लिव इन अ pollution free environment. Recently one of the members of parliament fled to Germany. Eligibility issued. So what is a diplomatic passport issued to designated members? इसमें वीजा की जरूरत नहीं. Every country is not giving visa on arrival. Some countries say कि okay, we will not give to entire population but we will give to your law makers. So MPs को देंगे. So they are issued diplomatic passport. Designated member authorized by the government on diplomatic assignment or official purpose. Holders of such pass have certain privileges also. India has visa waiver agreements with Germany and along with 33 other countries. Diplomatic holders visit these countries without a visa for 90 days. About Indian passport is government 7th schedule, you know, war and peace, extradition, citizenship, naturalization and aliens entry 17 hai, defense of India entry 1, all these matters are dealt by the central government, and article 81 ये आर्टिकल 11 of the constitution, all matters of citizenship parliament will make laws. So diplomatic passport, white color, all such things are there. Okay, official. So as common service center, common service center, India में जितनी पंचायत हैं, all those things celebrated, what you call, set up by Ministry of Electronics. Okay. So one of the three pillars, ये बहुत important है. What are the pillars of national governance plan? This is a factual thing. Okay. So what you call, it is a pan-India network, Aadhaar services, Bharat bill system and all financial services and all. Okay. World Press Freedom Index hai, they can ask. It is released by Reporters Without Borders. India third make of World Press Freedom Day hai. Theme ye tha, what is the ranking of India? 159 out of 180. Okay. Okay. Assam has launched an initiative, concept of core district in place of first kind of an concept of core district with district administration in place of existing subdivisions. Oh, okay. Core district sort of a new concept. Okay. So smaller administrative units below the districts and assistant district commissioner. Acha, इसीलिए I saw this. I'm reading for the first time. Okay. I saw an IAS officer, assistant district commissioner. Okay. Now they have started, say, usually क्या होता है? In Bihar there are 38 districts, 101 subdivisions and 534 blocks. 38 डिस्ट्रिक्ट है. अब थोड़ा सा इसमें कंसेप्ट समझ लीजिए, इसके बाद कुछ नहीं है ना. ओके. सो यूजुअली देर आर, जैसे दिस इज यूनाइटेड स्टेट्स ऑफ बिहार. ओके. सो इन यूनाइटेड स्टेट्स ऑफ बिहार यू हैव 38 डिस्ट्रिक्ट्स. यू हैव 38 डिस्ट्रिक्ट्स. डिस्ट्रिक्ट कंसेप्ट वाज गिवन. दीज टेक्निकली दे आर एडमिनिस्ट्रेटिव और रेवेन्यू डिस्ट्रिक्ट्स इनको कहेंगे. रेवेन्यू डिस्ट्रिक्ट 38 डिस्ट्रिक्ट में 38 डिस्ट्रिक्ट मैजिस्ट्रेट्स हैं. 38 district magistrate. हर डिस्ट्रिक्ट में डिपेंडिंग अपॉन द साइज ऑफ द डिस्ट्रिक्ट देयर आर सब डिविजन्स व्हिच इन यूपी इज कॉल्ड एज तहसील. बिहार में देयर इज नो कंसेप्ट एज तहसील एंड सब तहसील. सो देयर आर सब, जैसे मधुबनी डिस्ट्रिक्ट हैज 5 सब डिविजन्स. सो 1 2 3 4 and 5. देयर आर 101 सब डिविजन्स व्हिच इन यूपी एंड ऑल यू कॉल एट तहसील. अब in one subdivision there are 4 to 5 blocks. Up there are big subdivisions also. Siwan mein there are Siwan district or Chhapra district. Getting my point? In Katiyar you have I think 4 subdivision, 3 or 4 subdivision. Siwan you have 2 subdivisions, Siwan and Maharajganj. In one subdivision you have 10 blocks. Otherwise usually in a subdivision you have 4 to 5 blocks. Shekhpura has less. So you have 38 districts, 101 subdivisions and 34 ब्लॉक्स. ओके. अब क्या है, जैसे अपनी साड़ी दिल्ली ले लें. इन दिल्ली देर आर 11 डिस्ट्रिक्ट्स. तो डीसीज कितने होंगे? यूपीएससी इंटरव्यू देने जाइएगा, दे विल बी जस्ट बगल में सामने देखिए ऑफिस ऑफ डिस्ट्रिक्ट मैजिस्ट्रेट. ओके. जस्ट 100 मीटर्स 200 मीटर्स फ्रॉम यूपीएससी. सो 11 डिस्ट्रिक्ट्स हैं दिल्ली में. 11 डिस्ट्रिक्ट्स आर देयर, पर पुलिस डिस्ट्रिक्ट 15 है. सो डीएम 15 11 है, पर डीसीपी 15 है. और डीसीपी लॉ एंड ऑर्डर, सिक्योरिटी, ट्रैफिक, फायर एंड ऑल, एयरपोर्ट, वो तो है ही. सो इन बिहार ऑल्सो देर आर 38 डिस्ट्रिक्ट्स बट 40 एसपीज बिकॉज देर आर 2 पुलिस डिस्ट्रिक्ट. व्हाट इज अ पुलिस डिस्ट्रिक्ट? पुलिस डिस्ट्रिक्ट मतलब ये डिस्ट्रिक्ट ही है, पर यहां जंगल है, बगहा में देर इज अ जंगल. सो देर कैन बी लॉ एंड ऑर्डर इशू. सो दैट इज फर्दर डिवाइडेड इनटू पुलिस डिस्ट्रिक्ट. सो एसपी वुड बी 2. Getting my point? Overall it is only 1 district. Overall 1 ही डिस्ट्रिक्ट है, लेकिन some areas are declared as police डिस्ट्रिक्ट. दिल्ली में सिर्फ 11 डिस्ट्रिक्ट है, पर चूंकि लॉ एंड ऑर्डर प्रॉब्लम ज्यादा है तो पुलिस डिस्ट्रिक्ट. एक्चुअली वी विल से देयर इज ओनली 11 डिस्ट्रिक्ट, पर वहां लॉ एंड ऑर्डर प्रॉब्लम हो जाता है तो एक डिस्ट्रिक्ट के अंदर दे क्रिएट अ सब डिस्ट्रिक्ट व्हिच विल बी एक्चुअली फॉर रेवेन्यू पर्पस इट विल बी सब डिविजन, बट फॉर पुलिस पर्पस इट विल बी district, and there will be an SP. जैसे बगहा in Bihar is a subdivision. It is just a mere subdivision तहसील, but there will be an SP, not subdivisional police officer, because it is a police district. Delhi में भी there are 11 districts, but police districts हैं 15. So अब revenue, सबसे पहले the term in Bihar if you'll go, it is written जिला समाहरणालय. जिला समाहरणालय. सो समाहरणालय और उनके ऑफिशियल साइन लिखा होगा जिला समाहर्ता. कलेक्टर इज कॉल्ड एज समाहर्ता. सो द ब्रिटिशर्स टुक दिस टर्म फ्रॉम अर्थशास्त्र वेयर समाहर्ता इज द पर्सन रिलेटेड टू रेवेन्यू. सो द पर्सन हु कलेक्ट्स रेवेन्यू इज समाहर्ता. सो द पर्सन हु वाज कलेक्टिंग रेवेन्यू इन द ब्रिटिश पीरियड ही स्टार्टेड बीइंग कॉल्ड एज कलेक्टर कॉल्ड समाहर्ता, एंड द प्लेस वेयर समाहर्ता सिट्स इज कॉल्ड एज समाहर नाले. दैट इज द हिंदी टर्म. सो रेवेन्यू पावर्स हैं डीएम के पास और एडमिनिस्ट्रेटिव पावर्स हैं, देन ही इज कॉल्ड एज. इन बिहार इन एसडीएम व्हीकल यू विल सी एसडीएम कम्स एसडीओ. So for administrative, revenue, land and related matters, he is subdivisional officer. But for magisterial powers, he is also having SDM cum SDO. Yani district magistrate cum collector. Revenue matters, he is collector. For magisterial matters, he is also having certain magisterial powers. Revenue. So in ये British का था, there are 790. So what they have started कि rather than subdivision, they have started some small sub districts. Okay, उससे क्या होगा कि there will be more senior IS officer as ADCs posted. People will get, the administration will get better. So they can ask a question. If you go back to this, if you will see here. Okay, if you will see here, जैसे Assam first core districts within a district administration in place of the existing system of civil subdivision. Smaller administrative unit below the district headed by additional district commissioner having powers and responsibility, decentralizing administration. So a sort of small district where senior officers will head the same. So subdivision होगा तो वहाँ SDM would be there, but a senior officer will head a district for better administration. These reforms are come. But what you need to know, normal district होता है और then there are police district. Commissioner, police commissionerate क्या होता है? Where magisterial powers are enjoyed by the police. That is police commissionerate system. ये पूरा system Britishers ने devise किया था to collect more and more revenue. So that is why the person who was in charge was called as collector. And in Hindi he is called as Samharta, and the place where he sits is called as Samharnalaya, because Samharta term has taken from Arthashastra, Kautilya's Arthashastra. So this we have done. 4 or 5 things you need to do. You will have more classes because this is only April to October. Okay, so you'll have more classes because I think this is enough. Okay, I have tried to cover holistically. Honestly speaking, syllabus बढ़ गया है because many those questions are asked. So it is not tough, but you need to give more effort and curtail time from wherever you know better कि किस चीज़ पे आपको curtail करना है और किस चीज़ पे you need to work hard. बाकी तो ठीक है, we'll have more conversations. For the time being, it is on April to October. Okay, thank you.